No, we can also very good. A batch of the applications filed by the state. For last 3 years, panel, we are out of employment. Regulation of outsourcing employee, more than 100 cases. In the leading case, my lord, stay was granted after 1 year. They filed after 1 year, and thereafter, my lord, not allowed the petitions to work. They will listed, my lord.
It's an appeal of 2017. The appellant has been sentenced with life imprisonment and with 20,000 fine. What should we take up?
Appellant in custody.
How many years of practice do you have? I'm asking you, Ms. Biswal. 15. 50.
Weekly list, item number 1.
Come to the order dated 4/11/2024.
Madam. Annexed 4. The relevant page is.
No. We please go through that order dated 4/11/2020.
4/11/2020.
Yes.
What should I ask for the notification?
No. We asked you whether you are having a copy of the lease. It is a Jawan lease. It has been granted in favor of that Durgapada Ghosh, who was a Jawan. So there must be some terms and conditions, because the lease deed, so far as is concerned, it is to be abide by whatever terms and conditions are there in that. That if you want to sell it, transfer it, then you are to first sell it to the government. If the government says no, then with the government's permission you can sell to the others. If you do not do, then it cannot be acceptable. That is the condition of the Jawan lease. Where is that? No, unless we know it, how can we appreciate the thing? Where is that lease? We have asked you from the government. No, it is not that. That is not the. You have that that you are referring to that miscase in some. That is not the permission. Permission is something different than what you have done in the Odisha Land Reforms Act. You have taken that one. That is not the permission under the Government Grants Act. It is totally different permission. Permission, if you have that lease deed, we can show you that there are clauses in that lease deed which says that if in, let us say, in X favor it has been granted, X is a Jawan, how he has to utilize. It is given for the agriculture purpose. So if he does not utilize it for the agriculture purpose, then the government has right to resume it. And if he wants to sell it also, then the first preference is to be given to the government. You will ask the government to purchase it. If the government says no, then with the approval or the permission of the government, he can sell. Otherwise, you are nowhere in the picture.
For this reason, this Honorable Court has passed order in WBC number, that is 9449/993, dated on 29/1/996,
indicating that the state government to inquire into the matter through a senior officer in the rank of a secretary, whether the Tahsildar has settled the land by misuse the power, then necessary legal and administrative action should be taken against the Tahsildar.
No, your
That is the
That was a general order.
suppose your land has been resumed. That is under which act? If it has been resumed, then it is under which act?
Orissa Sub-Settlement Act.
Under what provision you are to challenge it, that resumption? If there has been a resumption of the land, there is an appeal provision. Have you challenged it? You have challenged under the Odisha Survey and Settlement Act. That is not the right thing to be done. Once a land which was given to you by way of a lease is resumed under Odisha Government Land Settlement Act, then appeal forum, as you rightly said, the appeal forum is there. Have you approached the appellate authority? Why have you approached the Survey and Settlement Authority? And the provision is that appeal you have.
Sir, I have filed appeal, he has rejected it.
Where is that?
That is
That is not under this Government Land Settlement Act. You see that that is under the Survey and Settlement Act. Look at that appeal, Annexure 4.
Annexure 4.
Please come to that. Survey and Settlement Act. See that appeal that is mentioned in page number 32.
This case is section 22, section 2B of the Orissa Survey Settlement Act.
Yes.
I applied appeal in that section.
Is it permissible under that section you are to file? When a land has been resumed by the government under the government Odisha Government Land Settlement Act, there is an appeal provision. This is completely different provision. It is so far as the sanction of settled rent and modification of orders. There, if any objection is there, then that would be the order passed, and against that the revision lies to the Board of Revenue. That also you have not upheld. Board of Revenue, have you approached against this order? And even if you approach this order, that would not be done because it is for a limited purpose. See section 22. Have you got that Survey and Settlement Act?
That resumption order is not under challenge.
That is not challenge. That is exactly. Please come to section 22.
Section of a settlement of rent and modification orders passed on objection. When all such objections have been disposed of, the assistant settlement officer shall submit the settlement rent rule to the settlement officer with a full statement on the grounds of his proposal and a summary of the objection, if any, received by him. The settlement officer shall, of his own motion or an application without 30 days from the order passed on an objection preferred under subsection 1.
This chapter, Land Council, this chapter comes under chapter 4, and chapter 4 deals with settlement of rent. So, how the settlement of rent is to be made, provisions are there. It starts from section 18 onwards, and there would be a preliminary publication. And if anyone wants to file an objection, that will be filed. And if thereafter anybody is dissatisfied, then he can approach the Board of Revenue under revision, that is under section 25.
In this case, there is no notification. In this case,
we are asking you a very pertinent question, whether the Jawan's land, which was given on lease, that has been resumed by the government or not. You said yes, right? And if it is yes, and you say that the provision is there under the Odisha Government Land Settlement Act, we are asking you whether there is no appeal provision under challenge that section 3B of that provision. If resumption is there, let me show it the Government Land Settlement Act.
Section 3B.
3B, it deals with resumption
Resumption.
of land and imposition of penalty. This is, and this Odisha Government Land Settlement Act will be applicable because it is a Jawan lease, and it also section 3 3C, it says that the settlement of the land under this section shall be made in the following order of priority: cooperative, so on so on, ex-serviceman or armed. ଏଇଥିରେ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଗ୍ରାଣ୍ଟରେ ଦେଲେ ସେମାନେ ଲିଜ୍ ରିଜମ୍ପସନ୍ କଲେ ସେକ୍ସନ 3B ରେ, ରାଇଟ୍? Resumption kala pare clearly there is a provision for preferring an appeal under section 7. An appeal shall lie against any order made under section 3 or 3B. ହେଲା କାହାକୁ lie କରିବ ସେଟାକୁ clearly କୁହାଯାଇଛି. ଆପଣ ଏଇ case ରେ have you stated anywhere that against that resumption order any appeal was preferred under section 7?
My lord, have been meant like this, my lord. When already ROR has been issued in favor of that boss, already it is settled in his name. Thereafter,
that is not his private land. He has not purchased from XYZ. It is a grant of lease by the government.
My lord, the Tahsildar when granting the
So
ROR,
that recording of the land does not create a right. He cannot utilize as if he has purchased from XYZ and transferred to anybody. It's a government grant act. So the lease will be governed, and the that lease deed that would guide how you are to, in case you want to transfer it, then the provisions are there. That is why exactly from the very beginning we are asking you, please produce that lease deed which was granted in favor of that Jawan. That would show that what are the terms and conditions, why the lease was granted, and if you want to transfer it, then what is the procedure laid down there. Because the you see, this is say Supreme Court decision.
Very good to I am considered 2 to 3 weeks time. We procure that from the register. Why it doesn't register that copy? Basing on which the registration has been made and RR has been published.
Just take note of this decision also. It is under the government grant lease 2015 SCC, page 55. Tata Steel Limited versus State of Jharkhand. There it is stated that to understand the meaning and scope of so and so, the following factors are required to be examined. Purpose for which the grant was made, number 1. The terms and conditions upon which the grant was made, number 3. Various contingency under which the grant could be terminated in full or in part, number 4. The scheme of the grant. So once it is a grant of government under this Jawan, it has been granted. So it will be governed by whatever they are in that. So that is why verification of that Jawan lease is very much necessary. Whether he could have transferred to you merely because his name has been recorded in the ROR, as you said, whether he could have, on that basis, he could have transferred it. That ground you have taken in your writ petition. But it is to be seen that where from it flows. So it flows from the Government Grants Act. So the Government Grants Act ro jo lease ro principle achi taku deviate karigini se transfer kari pariboni. Se jodi kaku private lokotu kini thanda beto se apanku transfer kar dei thanda. It would not be. It would be governed by that Government Grants Act. Lease deed re thibo seithme apanku kahithilu je lease deed ta produce karo. Once it has been resumed, then the provision is also there. You have not availed. that provision, appeal provision.
So I do undertake to furnish that the papers
That order
for
was
which period of
not-
15 days married. Because it's an old document we have to procure it.
Can you check up the decision of this court in the case of Rajkishore Das versus State of Orissa?
That Jharkhand case.
No, not Jharkhand, Odisha case. 1994 LR also. See if it is applicable to your case.
And this decision which you have given with your note, that is not taken all those things into consideration. Even this Narottam
Narottam.
case recently, the Honorable Supreme Court, that is a totally different that it is under Odisha Survey and Settlement Act. The ASO refused to, under that this court directed that no, ASO cannot have. But it is the totally a different case. It's a Jawan lease is a totally different concept. So Jawan lease re diya aitala, Jawan lease re apankar semane resumption kale, alternative for like ek tike se kond kale, de apno प्रत्येक केस को आपण कंसीडर करिवे एवं देखिवे आगे सी अल्टरनेटिव रेमेडीज एग्जिस्ट करिछि कि नाही फंडामेंटल थिंग सेम थी आमे रीड टाको एंटरटेन करिया पूर्वरु आमे देखियो पड़िबो जे गवर्नमेंट ग्रांट्स एक्ट रो बा ओडिसा जदी गवर्नमेंट लैंड सेटलमेंट एक्ट रो जदी रिज्यूम हे गला ताले आपण रिजम्पशन प्रोसीडिंग अगेंस्ट आपण जाइछंती कि नाही से जो गुडा को स्टैट्यूटरी रेमेडी आपण को पाखरे अवेलेबल थिला जो प्रोविजन अपन अपील कले से प्रोविजन अकॉर्डिंग टू अस दैट इज नॉट द करेक्ट प्रोविजन सेटा होची गोटे रेंट फिक्सेशन रे से अपील टा करा जाय यदि रेंट कार somebody is dissatisfied that is the provision this chapter ta entirely dedicated is it right so you can take time there is no problem how much time you want
3 weeks
okay. On 4/11/2024, he asked the Learning Council for the petitioner as to whether he is having a copy of the lease which was granted to Durga Pada Bose, a Jawan, in WLL case number 961 of 1973, from whom the petitioner purchased a Kursun 100 decimal of land of Tahsil Sabik plot number so and so. The Land Council for the petitioner seeks some more time to produce the copy of the lease deed. From the date chart produced by filed by the Land Council for the petitioner, it appears that in 1973, the government of Odisha was pleased to allot a piece of land bearing so and so in favor of the Jawan, Durga Prasad. And accordingly, in the very same year, the land in question was mutated and ROR/Patta was issued in the name of Durga Pada Bose. Have you stated anywhere that when that resumption was made by the government under section 3B?
No.
Yes.
In paragraph 3 of the petition, my lord, he has mentioned that the land in question who also muted in Tahsil office and ROR upon by Khata
No,
number
we are not on that. When that land was resumed and whether you purchased that land by way of sell deed after that resumption or prior to that. Resumption ହେଲା ପରେ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଖାତାକୁ ରେକର୍ଡ ହେଇଗଲା ସେଇଟା ଜଣା ପଡୁଛି ଏଠୁ ଆପଣଙ୍କର ଅର୍ଡର ରୁ ଜଣା paragraph 7 ରେ କଣ ଲେଖିଛନ୍ତି?
Section 80 of the Whaler Act empowers the authorities concerned to convert agricultural land for the purpose other than agriculture on the application made by the Rayat in the prescribed form. Thus, on the strength of the ROR Annex 3 vis-a-vis the provision of Section 80 of the Whaler Act, petition submit application for conversion of the land in question to Gharwari in the prescribed form.
It cannot be, Mr. Counsel, it cannot be. ଘରବାଡି ହେଇପାରିବ ନାହିଁ ଗଭର୍ଣ୍ଣମେଣ୍ଟ land ଆପଣ ଏଗ୍ରିକଲଚର ପର୍ପସ ରେ ଦେଇ ତାକୁ ଅନ୍ୟ କିସମକୁ କରିପାରିବେନି ଆପଣ. That is the speciality in that case, Government Grants Act. Date ଦେଇନାହାନ୍ତି ତ. But it appears from the appeal ଯୋଉ order ଟା ଆପଣ ଫାଇଲ କରିଛନ୍ତି ସେଟା ସେଥିରୁ ଜଣା ପଡୁଛି land ଟା ଯୋଉ ତହସିଲଦାର ପୁଣି ନେଇକିନି ତହସିଲଦାର settle the land so ପୁଣି ଗଭର୍ଣ୍ଣମେଣ୍ଟ କୁ ବ୍ୟାକ୍ କଲା ଏଟା ଲେଖା ହେଇଛି ଗୋଟେ ଲାଇନ ରେ. Date ଲେଖା ହେଇଛି ସପାର ଆପଣଙ୍କ page number 34 ରେ ଲେଖା ହେଇଛି ମଝି part ରେ. In the status report it is indicated that Sabiq plot number so and so in favor of government Anavadi khata number so and so, the Hall plot number so and so stands in favor of the general administration department.
Thereafter, High Court has interfered in the matter and formed a committee and directed the secretary to verify it.
May kindly see page 33.
Let
33.
He never assailed the resumption order. He only filed this appeal assailing the
No, no.
when was the
non-conditional
resumption done?
Resumption
That was
କେବେ
not in
ହେଇଛି
the
ସେଟା?
Exactly, that is why we are asking him whether it is his case that has it been resumed or when it has been resumed.
କାରଣ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଗ୍ରାଣ୍ଟସ ଆକ୍ଟ ରେ ଦେଇଦେଲା ପରେ ସେ ଯଦି ଟର୍ମସ ଆଣ୍ଡ କଣ୍ଡିସନ କିଛି ଫ୍ଲାଉଟ୍ କଲା ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଗ୍ରାଣ୍ଟସ ଆକ୍ଟ ରେ ଅଛି
Resumed.
ରିଜ୍ୟୁମ କଲା। ଏଇଟା ଯଦି ହେଇଛି ସେଇ ପ୍ରୋସିଡିଓରେ ସେଟା କେବେ ସେ ନିଜେ ବି କହିପାରୁନାହାନ୍ତି କେବେ ହେଇଛି ସେଟା ଆଉ ହେଇଛି କି ନାହିଁ ନା ଏମିତି ହାଇକୋର୍ଟ ଙ୍କର ଯୋଉ ଅର୍ଡର ହେଇଗଲା ସେ ଯୋଉ ଓଜେସି ଇଏରେ ସେଇଥିପାଇଁ ସେଟା ପଳେଇ ଆସିଲା ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଲ୍ୟାଣ୍ଡ ଆପଣ ତ
କଣ ଯାହା କହିଲେ ତ
ଯାହା କହିଲେ ଆପଣ କହିଲେ କଣ
ହାଇକୋର୍ଟ ଅର୍ଡର ଅନୁସାରେ ଯାହା ଥିଲେ ଯେତେ
ତାହେଲେ resumption କାହିଁ କହୁଛନ୍ତି?
ଆସିଲେ ଜଣେ
ଆମେ ଆପଣଙ୍କୁ ପଚାରୁଛୁ ରିଜମ୍ପସନ ହେଇଗଲା ଅପିଲ ପ୍ରୋଭିଜନ ଅଛି ଆମେ ଚୁପ ହେଇ ରହୁଛନ୍ତି ନା
ଜାଣିନୁ ମାନେ ଆପଣ case ଆପଣ ଜାଣିବେ ନା ଆଉ।
କେସ୍ ଆପଣ କିଏ ଜାଣିବ ଆପଣ ଯେତେବେଳେ କୋଶ୍ଚିନ୍ ଆମେ ପଚାରୁଛୁ ଆପଣ ତ ଚୁପଚାପ ହେଇ ରହିଯାଉଛନ୍ତି ନା ଯଦି ଆମେ ସେଇଥିପାଇଁ ପଚାରିଲୁ ଯେ ଅପିଲ ପ୍ରୋଭିଜନ ନ କରି ଆପଣ ଡାଇରେକ୍ଟ କାହିଁ ହାଇକୋର୍ଟକୁ ପଳେଇ ଆସିଲେ ଯଦି ରିଜମ୍ପସନ ହେଇଛି ଆପଣ କହିଥାନ୍ତେ ନା ଆଜ୍ଞା ସେ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଗ୍ରାଣ୍ଟ ଏଇ ଯୋଉ ସେଟଲମେଣ୍ଟ ଆକ୍ଟରେ ଯୋଉ ରିଜମ୍ପସନ ପ୍ରୋସିଡିଓର ଅଛି ସେ ରିଜମ୍ପସନ କରିନାହାନ୍ତି ହାଇକୋର୍ଟର ସେଇ ଯୋଉ ଅର୍ଡରଟା ହେଇଥିଲା ସେଇ ଯୋଉ ଓଜେସି 1993 ରେ ସେଇଥିପାଇଁ ସେ ଇଏଟାକୁ ଲ୍ୟାଣ୍ଡଟାକୁ ବ୍ୟାକ୍ କରିଦେଇଛନ୍ତି ଆପଣ ତ ଟୋଟାଲ କିଛି ଇଏ ନାହିଁ ଆପଣ ଯୋଉ ପ୍ରୋଭିଜନରେ ଚାଲି ଆସିଲେ ସେଇ ପ୍ରୋଭିଜନ ହିଁ ସେଟା ହଉଛି settlement of rent ଆପଣ ଦେଖିଲେ ତ rent that is not applicable
appellate order ରୁ ଯାହା ବୁଝା ହେଲା ସେଟା ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଖାତାକୁ ନେଇ ଆସିଛନ୍ତି because of that order in that OJC. The appellate court itself says that there has been no inquiry while it is proceeding, it has been done. ପୁଣି ହଁ ମାରିଲେ କଣ ସେଟା
no inquiry, they are not done any inquiry. While doing this, no inquiry has been conducted by the government, even if the secretary is appointed as per High Court's order. Results mentioned in that order itself clearly indicated that there is no inquiry, nothing.
ସେଇଟା ସେଇଥିପାଇଁ ବ୍ୟାକ୍ କଲା ନା କଣ ପାଇଁ ବ୍ୟାକ୍ କଲା ମାନେ ରିଜମ୍ପସନ ହେଇକି ଗଲା ଆପଣଙ୍କର ଯୋଉ ଲିଜ୍ ପ୍ରିନ୍ସିପଲ ଡେଭିଏଟ୍ କଲେ ବୋଲି ସେ ଯବାନ ସେଥିପାଇଁ ବ୍ୟାକ୍ କଲା ନା ଏଇଟାକୁ ଏଥିପାଇଁ ବ୍ୟାକ୍ କଲା ଏଇଟାକୁ ଜଣା ପଡୁନି କ୍ଲିୟର
Sir, I pray can we issue the notice?
No, ଆପଣ prayer ଟା ଦେଖନ୍ତୁ।
So that everything can be clarified.
Mr. Patnaik, issue notice କଣ ମା ଆପଣଙ୍କ prayer ଟା ଦେଖନ୍ତୁ। You are challenging resumption. Settlement officer କଣ resumption କରିବେ ସେ ଖାଲି recording କରିବେ।
ହଁ ଆପଣ ପ୍ରେୟାରରେ ବି ଲେଖିଛନ୍ତି ରିଜମ୍ପସନ
Resumption stroke restoration.
ହଁ ଆପଣ କ୍ୱେଶ୍ଚିନ୍ ହଉଛି ଦ ରିଜମ୍ପସନ ଅଫ ଦି ଲ୍ୟାଣ୍ଡ ମୁଁ ସେଇଥିପାଇଁ ପଢିଥିଲି resumption to the government khata by the so and so is bad in law ତ ଆପଣ ନିଜେ ହିଁ କହୁଛନ୍ତି ରିଜମ୍ପସନ ଦେଖିଲା ବେଳକୁ ପ୍ଲିଡିଂ ହିଁ ନାହିଁ ରିଜମ୍ପସନ କେବେ ହେଲା ଯଦି ହେଇଛି ଆପଣ କାହିଁକି ତାର appeal ଫାଇଲ କଲେନି provision is there
That is why we are asking you କାହିଁ କରିନାହାନ୍ତି but ଯଦି resumption ହେଇନି you need not file appeal. You have to take instructions.
ଯଦି ସେଇ ଅର୍ଡର ବଳରେ ଅନେବୁଲ ଦିସ୍ କୋର୍ଟ ର ଯୋଉ ଡିଭିଜନ ବେଞ୍ଚ ର ଅର୍ଡର ବଳରେ ସେ ଯୋଉ ଓଜେସି 93 ସେଥିପାଇଁ ଯଦି ଲ୍ୟାଣ୍ଡ ଟାକୁ ନେଇ ଆସିଥିବେ ତାହେଲେ obviously they have not gone through this resumption proceeding but ଯାହା ହେଲେ ବି ଆପଣଙ୍କର କ୍ଲିୟର କରିବା କଥା ନା କିଛି ନାହିଁ ଆପଣ
instruction
କଣ ଲେଖିଲେ in the prayer portion the petitioner has prayed to declare that resumption public restoration of the land in question to government khata by the settlement officer oblique assistant settlement officer oblique additional sub collector is bad in law. When we put a pertinent question to the land and council that whether in the case in hand the resumption of the government land has been made under section 3B of the Odisha Government Land Settlement Act 1962? And if so, why the appeal provision under section 7 of 1962 Act has not been resorted to Land Council for the petitioner, 6 for an adjournment?
cost title ବି ଲେଖିଛନ୍ତି 3B of OGLS Act for
And
କେବେ କେବେ
would add the and and in the cost title also it is mentioned as section 3B of the OGLS Act, है ना? So separate लिखिए put of this matter.
You also examine whether without resumption whether the Tahsildar settlement officer could have done that. ଚାରି ସପ୍ତାହ ହେଲେ ଆଜି କେତେ ଆଜି ହେଲା 17 ହେଲେ 15 କି 16 କି ନେକ୍ସଟ ତାପରେ ବି
21st on 21st memo file taken on record.
ଏଇଟାରେ କଣ ପୁରୁଣା ଅର୍ଡର ଗୁଡା ଥିଲା ଟିପି ଦେଲେ
କଣ୍ଟାକ୍ଟ ଦେଖିଦେବେ ସେକେଣ୍ଡରେ କଣ ଅର୍ଡରଟା
ଥରେ ଅର୍ଡରଟା ନଥାଏ ତ ୱିଥାଉଟ୍ ରେଫରେନ୍ସ ଟୁ ଇଟ୍ ସେମ୍ ଜିନିଷଟା ଲେଖିଦେଲେ ହବ ନା ସେ ଡିଟାଚ୍ ହେଇଗଲେ ଗୋଟେ 17 9ରେ ଗୋଟେ ଅର୍ଡର ଅଛି ପ୍ରୋବ୍ଲେମ ହଉଛି ଅଲଗା ହେଇଗଲେ ଇଏ ଅଲଗା ଗୋଟେ ପଳେଇବ ସିଏ ତ ଅଲଗା ଗୋଟେ ପଳେଇବ ସେ ଜାଣି ହବନି କଣ ପାଇଁ ସେଟା ଥିଲା
ଇଏ ବି ସେଇ ଜବାନ ଲିଜ୍ ମ୍ୟାଟର ଆଉ ସେଇ ଲୋକ ବି ସେଇ ଲୋକଠୁ କିଣିଛି ସେ ଯୋଉ କଣ ଦୁର୍ଗା ପ୍ରସାଦ ସେମ୍ ତ ସେ ଟାଇପ କରିଦେବେ ଅର୍ଡର କରି
ସେ ଦୁର୍ଗା ପ୍ରସାଦ ବର୍ଷ वन ପରିଡାକୁ ବିକିଲେ ପରିଡା ଆକୁ ବିକିଛି
ନାଇଁ ଇଏ ଦୁର୍ଗା ଟୁ କିଣିନାହାନ୍ତି
ନା ଡାଇରେକ୍ଟ ଦୁର୍ଗା ପ୍ରସାଦ ପରିଡା ବିକିଲେ ତ୍ରିଲୋକନାଥ ପରିଡା ଦେନ୍
ନାଇଁ ଗୋପୀନାଥ କୁହାଣ ଲେଖି ପୁରା ଆପଣ ରେଜିଷ୍ଟର୍ଡ ସେଲ୍ ଡିଡ୍ ଟା ଦେଖିଲେ ଲେଖା ହେଇଛି
ସେକେଣ୍ଡ वन
ହଁ ସେକେଣ୍ଡରେ
ହଁ ଦୁର୍ଗା ପ୍ରସାଦ ଆମେ ଦିଟା ପିସ୍ କିଣିଛନ୍ତି ଦିଟା ପିସ୍ ଗୋଟେ ଡାଇରେକ୍ଟଲି ଦୁର୍ଗା ପ୍ରସାଦ ଠୁ ଆଉ ଗୋଟେ ତ୍ରିଲୋକନାଥ ଠୁ ଦିଟା ପିସ୍
ଟୋଟାଲ ତାକୁ କେତେ ମିଳିଥିଲା 5 ଏକର
5 ଏକର ପରା ଜବାନ ଲିଜ୍ ଟା ଚାଷ କରିବା ପାଇଁ 5 ଏକର ମିଳେ ସିଏ ତାକୁ ଘର ପ୍ଲଟିଂ କରିକି ଦେଇଥିଲେ So 2 appeals, you have filed 1 writ petition. There were 2, you have filed 2 appeals.
In second case, there are 2 appeals.
But here 1 writ petition, okay?
Yeah.
Item 2.
From 2 by virtue of order dated 12/11/24, I have filed an I and I have been allowed to apply that 2 person as a party, and I have already filed my consolidated cost title.
Who is appearing for the?
My lord, yeah.
You are there. When the matter was taken up on 12/11/2024, Mr. Pari was there, and in the page number 3 of the order dated 12/11/2024, he made a submission that we have recorded it. Mr. P.K. Pari, Learning Deputy Solicitor General of India, submitted that against the order of the Appellate Authority, there is a provision for further appeal, and the order of Appellate Authority is also very clear that the appeal against said decision lies to so and so within a period of 45 days from the date of receipt of the notice, and he seeks 10 days time to obtain instruction as to whether the petitioner preferred an appeal or not, and if so, what is the result of the said appeal.
My lord, in this context, my lord, the petition has not preferred the revision, my lord, against the appeal order of the appellate authority, my lord.
Okay. Now, the next question is that come to page number 2 of that order, 12/11/2024. पाइले सेकेंड पेज को पढ़े आसନ୍ତୁ 12/11/2024 सेकेंड पेज को आसନ୍ତୁ. Please read it out. Learned counsel
for the petitioner submit that against the order of dismissal from railway service passed by the authority against him, he preferred an appeal on 28/3/2018 and the appellate
Please go slowly.
Sorry, and he preferred an appeal on 28/3/2018.
Yeah.
And the appellate authority by wide order dated 10/8/2018 without giving any opportunity of hearing to him considered the inquiry report and the appeal memo and the conclusion on the charges and came to hold that the punishment imposed by the disciplinary authority was appropriate.
Yeah.
Learned counsel for the petitioner drew the attention of this court to Rule 24 of the Railway Servants Discipline and Appeal Rules 1968, which provides that where the penalty of dismissal, removal, compulsory retirement, reduction, or withholding of increment has been imposed, the appellate authority may, at its discretion and if it consider is necessary, give the non-gazetted railway servant a personal hearing before disposing of the appeal. And at this personal hearing, the railway servant may be accompanied, if he so chooses, by another railway servant employed on the same railway administration, office of the railway board, its attached office or subordinate office as the case may be, in which the appellant was or is working, or an official who is not a legal practitioner of a railway trade union recognized by the railway administration on which the appellant was or is employed. Learned counsel for the petitioner further submitted that the appellate authority in the order dated 10/8/2018 has not stated that there was no necessity for giving personal hearing to the petitioner and therefore the petition has been seriously.
So that was his submission.
Right.
So once he was dismissed and he preferred an appeal, here he has perused just the appeal memo and he has not, admittedly, no opportunity of hearing has been given. He has considered the inquiry report, appeal memo, conclusion of charges, and held that the punishment is. So the provision is there in that rule which he placed, 1968 rules. So if the he feels it necessary, the appellate authority, then it is to be given. So if you say that it is not necessary, you are to record it that in view of the factual scenario, there is no necessity of giving personal hearing to the. So that we have pointed out that there is nothing in that order of recording by the appellate authority that there is no need for giving opportunity of personal hearing to the, because once you say that a personal hearing is to be given, then he can take help of another railway servant. So that's a very vital right which has been given. तो आपण पाखे अपील मेमो फाइल गला आपण ताकू देखि देले सेठी बसिकिनी तार फाइंडिंग ए कर दरे ना ठीक पनिशमेंट ठीक अछि. Very easy to do this.
Given opportunity, man. As per my instruction, man.
Yeah.
The charge official, married man.
Yeah.
After receipt of the major penalty case file, inquiry officer Chief Local Inspector Bhubaneswar decided to conduct preliminary inquiry on dated 21st September.
We are not asking you what you have done before imposing punishment. We are asking you what you have done after the filing of the appeal. It's totally two different things. He has challenged it in the appeal. Appeal says that If the appellate authority says that it is necessary, then this thing has to be done. If you say that it is not necessary, you have to record it that no, it is not necessary. You have not recorded. So once you have not recorded, then there is no such finding that it is not necessary. Then if you would have given him an opportunity, the appellate, he could have taken the help of another railway servant and could have convinced the appellate authority that this order of punishment which has been imposed, that is not in accordance with law.
My lord, in this, my lord, may I submit, my lord. During this pendency of this OA, this OA that is 540 of 2018 before the learned tribunal, the petitioner has preferred another OA that is 585 of 2021, and that was disposed of directing the petitioner to prefer a revision appeal, and he has challenged the same before this honorable court by the petition number 6952 of 2022. And this petition was disposed of with the order that the tribunal lacked jurisdiction to interfere in passing the order, that the tribunal lacked jurisdiction to interfere in the facts-finding report submitted by the CRS in the railway accident case and dismissed the OA number 585. And the honorable court affirmed the view taken by the learned tribunal in OA number 585 of 2021 and permitted petition to pursue remedy before the higher authority. And he has not done so.
No, that against this particular order, against the order of dismissal, this writ petition has been filed challenging the order dated 8/12/2020, and that OA number is 260/540 of 2018. So why that 260 was filed? Which order he challenged before the tribunal?
He is challenging order of passed in OA number 540 of 2018.
You come to page number 42, running page 42. There it is mentioned what he has challenged in the OA. Page 42 रे lekha heichi je 1 2 3 4 5 6 lines from the bottom, top. Being aggrieved, the applicant has filed this OA. This OA means seeking to quash the memorandum of the charge number 1, order dated of the DA dated so and so, order of the so and so, and to declare the initiation of the disciplinary proceeding against him as illegal, arbitrary, and no basis on. So this was the fair challenge, and the learned appellate, the original application was allowed to an extent. That is in paragraph number 15. Come to paragraph number 15.
On examination of the stand taken by the applicant in his appeal order of the appellate authority dated 10/8/2018 in respect of the applicant and an order of the appellate authority in respect of the local pilot, we find much force on the submission of the learned counsel for the applicant that this is a case which falls within the parameter of gross discrimination offending to Article 14 and 16 of the Constitution of India, which is also opposed to the instruction of the Railway Board dated 21/8/2012. Hence, the order of the appellate authority dated 10/8/2018 in respect of the applicant is hereby quashed, and as a consequence, the matter is remitted back to the appellate authority to reconsider imposition of lesser punishment in the light of the punishment imposed on the local pilot by the appellate authority. It is also made clear that in such an event, the applicant shall not be entitled to any back wages on the date of dismissal till his reinstatement, but he will be entitled to notional fixation of his pay. The entire exercise shall positively completed within a period of 30 days from the date of receipt of a copy of this order.
So it was remitted back to the appellate authority to reconsider imposition of the lesser punishment. That is why he is aggrieved. that appellate authority रे मते जदि chance दिया है था personal hearing दे था, I could have convinced that तेणु
I'll take instruction on that document.
Huh?
I'll take instruction on that.
No, instruction आपण पूरा देले आपण कहउचंदी जे ता against appeal येइनी and the order is very clear. You come to the appellate authority order. जोटा कि appellate authority ର order टा अछि परा आपण annexure 6 is the order. You come to page 1. ସେଇପାଇଁ ଆମେ ଲେଖିଲୁ ଏଟା instant case कौन हला paragraph तापरे major penalty हला. Now you see I have gone through the case in details including the inquiry report and your appeal. I find that the process of inquiry has been followed. You have been given sufficient opportunity to prove your innocence, and after applying my mind adequately to, I have come to the conclusion that this is the order. No opportunity was given. And the rule says that if you say that no, that is not at all necessary, you are to record. And if you say that it is necessary, then he has to be given an opportunity so that he can engage another railway servant to assist him. That has not been done in this case. Neither you have recorded that it is not necessary, nor you have given it. So that is why he has challenged this order before the. We have not issued notice in this case, Farah. Huh?
May I interrupt, my lord?
Yeah.
May I interrupt? My lord, whatever consequential benefit he has claimed to can be calculated on notional benefit, not as a back purchase.
Why he preferred appeal, Mr. Parhi? Why he preferred the appeal against which order he challenged the approach the tribunal?
Tribunal. It is 18/12/2023.
No. You come to the appellate authority order. The appellate authority
10/8/2018, my lord.
Yes.
10/8, right?
Yes.
That was because the major penalty was imposed.
Reduced
And,
to yes.
Right, and he was dismissed from the railway service with immediate effect. That is how he preferred that appeal. And the appellate.
For lesser penalty.
The appellate authority order is annexure 6. He has said that the entire thing is to be quashed. It is not
Yes.
for only
The matter
lesser
referred back to the
penalty.
appellate authority considering the lesser penalty.
What is your appeal memo?
पंचायत में I have a note.
Please pass on.
Appeal memo not enclosed in the petition.
No, have you got a copy of that appeal memo?
Madam.
Please pass on. No, that lesser punishment मत दिया जाए बोलिए. तो entire proceeding को pass करा
Pass
जाओ.
करो. appeal memo का पास है.
appeal note नुहे आज्ञा appeal
appeal
memo
memo हाँ appeal memo का.
ଆପଣଙ୍କର appeal file କରିଛନ୍ତି ଲେଖା ହେଇଛି appeal ଟା file ହେଇଛି 28/3/2018 ରେ
ଆଜ୍ଞା.
ଏବଂ ସେଟା dispose of ହେଇଛି 10/8/2018 ये जो अपील टा फाइल करथिले तार अपील रो ये टा काहे
Yeah.
मेमो टा
Next to Rakhun,
Mr. Pari, where from you got that he has only prayed that it should be lesser penalty should be imposed? Where from you got it?
It's non-tribunal order police.
Rather, we find that he has prayed for to quash the entire proceeding.
Yes.
What I'm submitting, my lord, the tribunal observed. As it was the same, very wording I am reading, my lord. The appellate authority dated 10/8/2018
No,
respect
the
to the appellate
tribunal has
authority
observed
hereby
like that.
quashed.
That is why he has challenged the tribunal order. But you are
Yes,
just making a submission that even before the appellate authority, he had no prayer to quash the entire major penalty. He has just said that instead of major penalty, please award the, please give us the minor penalty. He says, no, that is not the thing. But we are asking him to provide us that appeal memo.
But may I pray, my lord, keep it to next week, then I'll properly prepare and assist.
We are noting what the submission was made, that in fact he has not preferred any approached any revisional to
Authority,
that
yes.
revising authority. That you have
Yes,
taken
ma'am.
instruction. You have
Yes, yes.
And madam, one more thing, my lord, as per my instruction, paraphrase comments, the petitioner has been given sufficient opportunity to prove his innocence during the appeal, ma'am. He has been given opportunity on that.
ଆପଣ ଦେଖିଲେ ପରା appeal order ଟା ଦେଖିଲେ
I'll take instruction on that also.
ଆପଣ appellate authority
I'll take instruction.
ଟା ନିଜେ ଦେଖିନି enquiry report ଦେଖିଦେଲେ appeal memo ଟା ଦେଖିଦେଲେ କହିଲେ enquiry ଠିକ ହେଇଛି ସବୁ ଠିକ ଠାକ follow ହେଇଛି ବାସ୍ confirm.
I have to take instruction on this.
Right? There might have taken stereophonic,
And his stand is their entire repetition of stand होची सेया जे मते opportunity देई नांती rule टा एया सब कोर्ट ହେଇची जोटा हमें जो order टा आपन पढ़ी प्रथम हो servant discipline and appeal 1968. The order dated 12/11/2024, Mr. P.K. Paril and Deputy Solicitor General of India, along with Mr. Bushai, Land Central Government Council, submits that against the order of the appellate authority, the petitioner has not preferred has approached the revising authority. Stop. However, the Land Council submits that he has received the Parawai's comment that before the appellate authority also the what is your instruction that पढ़िले कौन जो लिखा है appellate authority पाकरे
the order passed by the appellate authority order dated 10/8/2018 has been acknowledged by the petitioner on dated 13/8/2018. Petitioner, without preferring a revision appeal to the next higher authority, that is Principal Chief Operation Manager, East Coast Railway Bhubaneswar, Revisionary Authority, and being aggrieved with the order of the appellate authority, petitioner filed an original application number 540 of 2018 before the learned tribunal.
ओहो आमे कौन पचारछु अपन कौन कहते appellate authority पाखरे opportunity दिया हिची बेली कौन Parawai's comment अछि भी
My lord, petitioner has been given sufficient opportunity to prove his innocence before the appellate authority.
लिखाई जी appellate authority पे देखो कौन लिखले sufficient कौन wording टा कौन
My lord, appellate authority went through the case in detail, including inquiry report and appeal.
Mr. Counsel,
Sorry, before
please read the exact language which you
My lord, may I read the before line? The appellate authority went through the case in detail, including inquiry report and appeal against the punishment order, and found that due process of inquiry has been followed. Petitioner has been given sufficient opportunity to prove his innocence.
The petitioner has been given sufficient opportunity
to prove his innocence.
to prove his innocence. Is it before the appellate authority?
That part is not.
Then?
Sorry, that part is not.
Don't try to bluff.
No, madam. Sorry, madam.
This is unfortunate.
I just read only that line. That was that is the fact. That is not there.
Only. Stop. The Mr. Pari during course of argument submitted that before the appellate authority, the prayer of the petitioner was just to reduce the major penalty, to which the London Council for the petitioner disagrees and submits that he will produce the appeal memo on the basis of which the appellate authority passed annexure 6. Put up this matter.
Next to the
Next week. Place this matter on
24th
of
May I pray, my lord? Better because the instruction received, we file the counter lordship, give little bit more time, 10 days. Then and then meanwhile you file the counter.
Let him file that appeal. Let him file the appeal memo next week. Thereafter, we will pass. Yes, next.
Item 3.
Part B is the amendment, my lord. Part B is the amendment.
Application by James Mark for amendment of the restriction in the ROR filed today along with other documents which he wants to return for professional details. Where is that?
Let flag B. 4171.
And he has been served on the land council for the state. Yes.
Receipt is it new? No, how the copying do it? How this
ଦେଖିଦେବେ କାଲିକି ରଖିବା ନା କଣ ନା କଣ
ଦେଇଦେଲିଣି ଆଜ୍ଞା ସେ ଫଟୋଟା ବି ଫଟୋଟା ଲଗେଇକି ଦେଇଦେଲିଣି
Yes.
କିଛି ଖାଲି ଫଟୋଟା ହିଁ ଲଗଉଛି ଆଉ କିଛି ଲଗୁ
No objection though.
No, just formally.
IN number 4171 of 2025. There is an application for amendment. Copy of the amendment application has already been served on the land council. State. After hearing the land council for the petitioner, for the land council, the respective parties and going to the amendments taken in the interim of petition. Since the amendment shortfall is formal in nature and that there is no objection from the land council for the state, we are inclined to accept the prayer made in interim application. Accordingly, the proposed amendment shall now form part of the writ petition. The land council for the petitioner shall file the consolidated writ petition or she be mentioned file. Next figure, submit that you will file the consolidated writ petition during the course of this week, giving copy to the land council for the state, put up this message. 24 ଆସିଯାଉ consolidated ଆସିଯାଉ 24/3/2025. Yes.
Item 4.
On behalf of Minister Tribunal and Resource, my lord, due to personal difficulties, would not be appearing before the court. Kindly be adjourned to Friday.
ଆପଣଙ୍କର କେସ୍ ଲାଷ୍ଟ 2ଟା ତାରିଖରେ non appears सेटा ता पूर्वरु ए केस फाइलिंग हवा दिनरु खाली adjournment चलीछि
Only last Sunday.
हां
Last Sunday, so Friday we will get payment.
Monday, Friday, Monday, Friday. On the event change.
एटा माने आजि का ऑर्डर टा हबो ऑर्डर नंबर 8 ता देरु दीटा होची नॉन appears आ पांचटा होची adjournment रिपिटिशन टा काई फाइल कले जदी परिवार नाही हां
Only last Sunday.
Have you read what is the case about?
No matter.
Why?
मना करले आपण सीनियर मना करले नाही पढोनी
No.
You
Tell
belong to the same chamber.
Yes, ma'am.
Tell us what the case is about. On case phone.
My last Sunday, Friday.
File for you last time.
Seven or 98 order would a challenge. 87 रो गोटे order and 98 रो order टा challenges 2024 at application. Appeal provision achi. And the prayer he is making may not be. The lease was granted in favor of one Bharat Naik. He has never that lease was rejected in the meanwhile. He has not challenged. Resumed your version. This application. In the meanwhile, he has sold that land to the present petitioners. That original lessee has not challenged that resumption of lease. And they have come for a grant of lease. But the original lessee is not a party, and that resumption order, now they want that particular land should be granted in lease in their favor, and that application has been rejected. They have a provision of appeal in it.
That council is not appealing to that.
My last Sunday, Friday. My name is S.K.Sahoo. Sanket.
Have you understood the objection which has been pointed out by the Narayan Council for this state?
Yes,
He says that against the informed order there is an appeal provision under the Orissa Land Settlement Act, Government Land Settlement Act.
yes, ma'am.
You are not taking recourse to such appeal provision. You cannot directly come to this court challenging that resumption order.
Yes, ma'am.
Okay,
Yes, ma'am.
and you go to your senior, say that this is the preliminary objection which was raised by the Narayan Council for this state. That he prepare and answer at all.
Yes, ma'am.
Do not grant further adjournment.
Yes, ma'am.
Today is the 8th adjournment.
Yes, ma'am. God bless you.
These are already sort of 7
On
24th of March 2025.
Item 5.
Hello, this issue is regarding the rehabilitation appointment of the rehabilitation scheme of MCL. The Lordship had directed to file an affidavit with the 1989 rehabilitation policy, my lord. I have filed that affidavit that is at flag B, my lord. Lordship may kindly see. Flag B, man. Page 5 of that additional affidavit, my lord, is the rehabilitation scheme, uniform guidelines. Uniform guidelines for rehabilitation. The Lordship got
Yeah.
uniform guidelines for rehabilitation of the displaced persons' families due to SCCL projects at Sambalpur and Dhenkanal district. Why, my lord, the vision to place this arose, my lord, because the Lordship, as per the documents of MCL, they say that they had provided job to one other person of the original land outstate, who is my grandfather. So whether more than one person can be employed or not, that was the question, my lord. That is why I am placing, my lord, clause 3.
Is it that case where somebody else had been
Yes,
given
ma'am.
employment after he?
Pisa जो
Not piece
ले
of
date ले.
piece of ମାନେ
ସେଟାକୁ
କିଏ କହୁଛନ୍ତି ଆମେ
ଆମେ
ଜାଣିନୁ
କଣ ହେଲା?
ପିଇସା କଣ କଣ ହେଲା କଣ
My lord, clause 3 of that rehabilitation scheme, my lord. A family in the aforesaid context shall include the husband and wife, as the case may be, and their unmarried children, but does not include a major son who has been separated from the family on or before the date of notification under Section 4(1) of the Land Acquisition Act 1894. In respect of area village, he shall be treated as a separate family. So by the time this notification was issued, this land acquisition process was started, my lord. He was married, my lord. On January 1989.
But how much land was acquired?
My lord, it is over there. Your lordship may kindly see page 21.
How much?
1.40, my lord. Number 1, serial number 1.
1.40.
Yes, my lord.
Look at employment A 4B,
My
the
lord.
scheme which you have given us.
Yes, my lord. My lord, but in a similar case, what had happened? If your lordship may only, I will go to that.
But the scheme says you must have lost all your dwelling houses, 1/3 of the total holding, or this much area.
Yes, my lord. One member from the family sustaining loss of dwelling houses, homestead land, and agricultural land, not less than 1/3 of the total holding, shall be provided with the employment on a priority basis.
So one member.
One member of each family, my lord. I am saying I am a separate family, my lord. All those properties being ancestral in nature, my lord. I also had a claim. My father had a claim. So, my lord, I am also a landowner and a separate family, my lord.
No, Mr. Das.
Yes, my lord.
Now you have given this scheme, whether there is pleading to that effect in your writ petition.
My lord, yes, my lord. Your lordship
that you satisfy this scheme and this scheme tells like otherwise it may be necessary for amendment of the writ.
Your lordship may kindly see page 4, para 6.
Para 6, yes.
Towards the last, my lord. However, when he received no concrete response, my lord, your lordship may kindly see
paragraph 6.
Paragraph 6, my lord. Purata padi douchi. That being conscious that the cut-off date was fixed as 1/4/1995, on which date the petitioner, this is petitioner's father, my lord, was a major. The petitioner's father had been moving from pillar to post for nominating present petitioner for the rehabilitation employment, which he was originally entitled to, and such nomination is permissible. However, when he received no concrete response, the petitioner's father has been approaching the OP number 2 time and again, and which would be apparent from one such representation dated so and so, in which the petitioner's father has appraised the OP number 2 that the land of his father has been acquired for the purpose of Kalinga Bharatpur OCPs, and that his petitioner's father's name has been listed in survey as nominee of the land housey, and petitioner's father being major as on the date of acquisition, married, and in a separate mess, entitled to a rehabilitation job under one job for one family scheme. The OP number 2 acknowledges the receipt wherein the petitioner's father prayed for extending service benefit to at least one member of his family. This is the representation I had given, which is enclosed as Annexure 4, my lord. And this ground that I am a separate family having separate mess is entitled for a rehabilitation. My son is entitled as a separate, as a unit of separate family, my lord. And in case of, my lord, though the facts are quite different, my lord, in a similar case of land rehabilitation, in case of Eastern Coalfields, the Honorable Supreme Court had, your lordship, for a moment, the definition of family as far as this rehabilitation of land acquisition process is concerned.
When the notification was made?
Notification, my lord, although the exact date is not there, but your lordship may kindly see it is in 89 July.
1989 July.
Yes, my lord, I was paid the money.
Okay. So must be prior to that.
Yes, my lord.
It should be around 2/1/1989 as per Annexure 17.
Yes, ma'am.
2/1/1989. That is date of notification of it.
That will be yes, when it was circulated. Yes.
So when your marriage took place?
31st January 1989.
31st January 1989.
That is my instruction, my lord.
So that means when this notification was made,
yes, my
lord. You are not married, so you could not have been.
No. By the time notification was made, the notification, your lordship is asking about the rehabilitation scheme or the
rehabilitation scheme ro jo principle upon कहउजन ना मते separate family हिसाब रे गणित करिकिनी हमु मते दबार अछि in view of section 3
again
he shall be treated as a separate aid kora number 3 को आसन बटन file करचंदी
again
a family, please read it out once again.
A family in the aforesaid context shall include the husband and wife as the case may be and their unmarried children, but does not include a major son who has been separated from the family on or before the date of notification under section 4.1 of the Land Acquisition Act 1894 in respect of area village, he shall be treated a separate family.
Kindly see page 62, Annexure 17 for a moment. That was the impugned order of the MCL. May I read it? May I read from the very beginning? MCL has acquired 105 acre of AG land of Mauja Danara under LA Act from Kathi Sahu, son of Sahib Sahu, village Danara for mining purpose of Kalinga OCP SECL. Kathi Sahu, son of Sahib Sahu, village Danara is a category B land outfit as per uniform guidelines for rehabilitation of the displaced family due to SECL project at Sambalpur and Deccanal district, circulated by rehabilitation L number sponsor dated 2/1/1989 of Revenue and Excise Department, Government of Orissa. As per family genealogy supplied by the district authority, Kathi Sahu has 3 sons, Tirthavasi Sahu, Tripura Sahu, Basanta Sahu, and 5 daughters, Rekha Pradhan, Hira Pradhan, Jonna Dehuri, Gunjo Sahu, and Champa Pradhan. The district administration has tentatively identified Prabhati Sahu, daughter of Tirthavasi Sahu, Tripura Sahu, and Basanta Sahu, a son of Kathi Sahu, wide L number sponsor dated 22/10/1990 for rehabilitation benefit. While Prabhati Sahu, Tripura Sahu were provided with employment benefits in SECL, Kathi Sahu, son of Swanso, nominated his another son Dibakar Sahu for service in place of Basanta Sahu. Basanta Sahu is not his son. May I complete? Basanta Sahu was employed in Nalco. He had also undertaken in the same affidavit that he or any of his legal heirs do not have any objection if Dibakar Sahu gets service benefit in SECL. Basanta Sahu or any other heirs of the Kathi Sahu had no objection to the service of Dibakar Sahu from 1991 to 2013, that is for 22 years. After which the Basanta Sahu first came forward with a claim of rehabilitation benefit to one member of his family, filed his application dated 15/2/2013, addressed to the General Manager, Hingula area. Dibakar Sahu resigned from the service of MCL with effect from 5/11/2018, 3 years before the date of his superannuation, which would have been completed on 31/1/2022. MCL has provided 3 employment benefits to the family of Kathi Sahu, Hon'Ble Swanso against land acquisition. Dibakar Sahu had enjoyed the service benefit from MCL being nominated by Kathi Sahu in the place of Basanta Sahu from 1991 to 2018, that is for 27 years. MCL cannot provide a 4th employment benefit against the said land acquisition after providing all the due benefit to the family of Kathi Sahu Swanso.
That was the issue, that Dibakar Sahu is not the son of my
So what were you doing all these years when Dibakar Sahu was employed? What were you doing?
My lord,
Not you, but your father.
My father was approaching the authorities for
Where is it?
Your Lordship may
Could not have approached because by the time it was acquired in 1890.
He wasn't employed in Narco.
Then this
is why
petitioner was
no,
probably
he
not
was
born
employed.
also.
Pardon me.
Petitioner was not born also by that time.
Yes.
Maybe, but
Yes.
his father was actually entitled.
Yes.
Your Lordship may kindly see
Yes.
on the basis of there was a committee report in 2022, my lord.
No, come to 1990.
My lord.
90 cutoff date is 1996.
Yes, my lord.
Yes.
Your Lordship is whether I had.
I'm looking at your date chart.
Yes, my lord.
You've given 25/7/1996 for the cutoff date.
Yes, my lord.
Before that, where have you referenced it?
I was not born by that. I was not.
Your father.
My father could not have approached my lord because he was already employed under NALCO.
So that is why no job then.
No job, but
and you were not born, so he will get a job. His brother-in-law will get a job because of this false statement. Nobody has complained against appointment of Dibakar Sahu.
Yes, well, there has been some
objection. The petitioner's father has given no objection.
No objection. That was the issue on the first date itself, my lord, before your lordships.
Yes.
So that what they say, it is a pure fraud, my lord.
Pure fraud practiced by whom?
Fraud practiced by that Dibakar, my lord.
He could not have got it without all your family members.
There is no report to the extent that Pathi Sahu had nominated Dibakar Sahu, and he has changed his name also.
And the first representation of the petition in 2013 only.
Yes. Mr. Das, we are not satisfied.
My lord, in a similar case also, my lord, before this honorable court, what had happened, the same thing happened for so he was thrown out on the disciplinary proceeding. But the honorable high court said the person who were actually nominated and the
So when was he thrown out? Within how many years?
Within after 10-12 years, my lord.
Here he served.
He served
27 years.
Yes, my lord, he
Yes.
served. But my lord, there should not be any bar that the person who is actually eligible should not be getting the job because someone else has taken that benefit.
In fact, what she's saying is believable because we were not born then. So everybody was agreeable to Dibakar Sahu pretending to be Basanta Sahu.
Dibakar Sahu, along with other two sons also,
Yes.
being considered as separate families.
It is not correct that when the nomination was made in favor of Dibakar Sahu, you were not at all born.
But your father was alive. He did not complain. He did not complain then.
The father nomination and your family members also have no objection. All these things were taken into account.
Had he objected, inquiry would have been conducted. He would have been thrown out.
My lord, there has been some inquiries.
Where?
Your lordship may kindly say at a later stage, my lord, but it was there.
Later, after you gave your representation, there was.
Yes, my lord. So there at page 37. Of course, my lord, after I started representing, my lord. That is there.
Where is the decision you are relying upon?
My lord, it is two similar cases, my lord.
Give a copy to him or
Yes, my lord.
take a
Mhm.
in pursuance of the 6/3/25, Mr. Das has filed an additional affidavit of the petitioner along with the uniform guideline for rehabilitation of the displaced persons oblique families due to SCCL projects at Sambalpur and Dhenkanal district. The Land Council for the petitioner placed two decisions of this court in the case of so and so. The Land Council for the state placed the, which is that order under challenge?
Annexure 17, my lord.
Placed the impugned order dated 17/9/2024 under Annexure 17, which clearly shows that S.K.Sahoo, son of S.K.Sahoo, nominated his another son, Sahoo, for service in place of Sahoo, as Sahoo was employed in Nalco. And the said Sahoo enjoyed the service benefit from MCL, being nominated by Sahoo in place of Sahoo from 1991 to 2018, that is for 27 years. And it is further mentioned in the impugned order that MCL has already provided 3 employment benefits in the family of Sahoo, and it cannot provide a 4th employment benefit against the land acquisition after providing all due benefits in the family of Sahoo. The Land Council for the petitioner fairly submits that when the nomination of Sahoo was made, the petitioner was not born at that time. However, he submits that Sahoo was not the son of Sahoo. After perusing the impugned orders, when we are not inclined to interfere with the same, the Land Council for the petitioner placed the citations of this court, two decisions of this court in case of so and so reported WPC number and so on. The copy of which has been provided to the Land Council for the state to seek some time to go through this and put up this matter on 24th March 2023. 2025. We are just coming.
Item 6.
Last state your lordship directed to state for instruction regarding this contempt petition. ମାନେ connected matter
ଆପଣ ଯେତେବେଳେ ଇନଷ୍ଟ୍ରକ୍ସନ ମାଗୁଛନ୍ତି 1 week 10 days କାଇଁ ମାଗୁଛନ୍ତି? ଆପଣ ତ ଚିଠି ଯାଉ ଯାଉ 5 ଦିନ ଲାଗୁଥିବ। Take enough time so that you get instructions. Petitioner will not come again and again to this court.
connected matter my lord 24 days.
रिप्रेजेंटेशन ଟା डिस्पोज ऑफ ହେଇଛି କି ନାହିଁ ଏତିକି ତ କଥା 5/2 ରୁ ଆପଣ ନିଜେ କହିଲେ 17 ରେ ଆଣନ୍ତୁ ତାପରେ 19 ରେ ଆସିଲା ପୁଣି କହିଲେ ନାହିଁ ଏ ତ ନେକ୍ସଟ ୱିକ୍ ହେଇଯିବ ଭାବୁଛନ୍ତି
Two weeks after
ଏତିକି ତ ଜିନିଷ ନା
ଜାଣିପାରୁନି।
तो लेट इट बी ଆଉ ଗୋଟେ ସପ୍ତାହ ଆପଣଙ୍କୁ ଦଉଛୁ तो लेट इट कम ऑन 2 तारीख ରଖିଦो
Instruction.
seven
Huh.
Plan counsel for the state seek some more time to obtain instruction in terms of the order dated 5/2/2025 out of this matter in the week commencing from 7th April 2025.
जो आरटा कहउछन से नंबर टा भी दे देथांतु जोटा 24th को अछि कहउछन लेट हिम गेट इंस्ट्रक्शन कह दियंतु मन अछि नंबर
अच्छी मो लेखि
दे देथांतु सो दैट एटलीस्ट 24 को गोटे सरीबो एटलीस्ट
मान
7/6/2025 yes
मिस्टर नाय गोटे रिमाइंडर पठे दियंतु आरटा
Item 7.
7 also same हाँ सही
so the order flexible भी इतला
एका दिन हेतला सेम डे
इटा ऑर्डर हेतला माइलर
ने सी जो टाइम नहीं थिले सेम डे
हाँ सेम
fifth रे 7/4/2025 next
Item 8.
may I request madam can you I am on behalf of Suryakant Dwivedi can take this matter next week
have you filed that order sheet on 10/3/2025 submission was made that you have received the order sheet of LA case number 20 of 2020 and you will file during course of that week particular 10/3 so did you file that order sheet what is your good name
Santil Kumar Ved
ସେଦିନ ଜଣେ ସତ୍ୟଶିବ ଦାସ ବୋଲି କିଏ
actually my name is Samir Kumar senior advocate Samir Kumar Mr engaged in this case
so
he is non available to
no you are being asked a question whether you filed those documents he is engaged he will argue that is fine whether you have filed that
actually my I have not read the file man
why have you not read the file you don't want to learn anything so anytime you come to the court whatever file is that you read it so that when your senior also makes submission you will be able to follow
now in this case Mr. Who is to argue
Samir Kumar senior advocate Samir Kumar sir
for the next day.
and it has already been hard 3 adjournments has already been granted the case has already suffered 3 adjournments the Mr. Shantanu Kumar Behra and counsel submits that Mr. Samir Kumar Mishra, and senior advocate, is supposed to argue this matter. Stop. The order sheet of LA case number 20 of 2020 has not yet been filed. Put up this matter when you want. Next week or a week after. Put up this matter. The 2 weeks adjournment person with this matter on 7th April 2025.
In fact, on the first date, Mr. Mishra had argued the matter. Thereafter, it is being adjourned.
7th April 2025.
So he has to file an appearance memo. No, not as soon.
Appearance memo he filed in the meantime, है ना? And senior advocates of the appearance. Here.
Item 9.
Next week, man.
Or did we file out also? Same ground. You'll argue a same ground for adjournment.
Next week, madam.
The senior is appearing. Why is he not filing appearance memo? Bar will get something.
Memo for student 9. No. Ask Mr. Mishra to file the appearance memo.
Minor.
What is your good name?
Jagajan Soda.
So and so appearing on behalf of Mr. Samir Kumar Mishra, one senior advocate, 6 for an adjournment. No appearance memo has yet been filed by Mr. Mishra. Put up this matter on 7th of April 2025. The appearance memo shall be filed in the meantime. Yes.
And the appeal petition present.
The Mr.
Rupesh
Kumar Kanu, Senior Parent Counsel, Union of India is present. Yes.
Item 10.
Yes, item 10.
Lordship, the petitioner challenging the order dated 9/8/2024 passed by the opposition to Additional Commissioner Revision of Code 4 under Annex 6, my Lordship. My Lordship, the petitioner had filed one OSS case number 631/2022 before the court, the Additional Commissioner Additional Revision Code Bhubaneswar, my Lordship. In this case, the petitioner purchased the lease property from Sumitra Behera. Sumitra Behera, prior to purchase the same, Sarveswar Parida. My Lordship, the original leaseholder, namely Sarveswar Parida, my Lordship. My Lordship, have a glance. Annexure 3, page 44, WC case number 162/23, आवेदनकारी सर्वेश्वर परिडा, my Lordship.
Lease?
Lease case number, WL case number, Wasteland case number 162/23.
No. The page 58. There it is mentioned that the petitioner has not been able to submit the certified copy of the Wasteland lease.
My Lordship.
As a result, the name of the lessee, his caste, age, so and so, would not be established by the petitioner.
My Lordship.
The flow of the title of the suit land could not be established in favor of the petitioner. So, are you now in having that?
Yes, my Lordship. My Lordship. I have a glass page number 57. My Lordship. Page number 57. Page number 57.
Yeah.
Para 3. The PWR from S.O. Jubra, Kotak, by letter number 22/17 dated 22/7/2023 reveals that in Sabik and Halkata, the Sudland stand recorded in Abada Ojugya Onavadi with Kisama Jungle, changing the Kisama Jungle land to non-forest Kisam and use it beyond the jurisdiction of the Revision Commissioner under the Forest Conservation Act. My Lordship, have a glance, page number 50, my Lordship. Annexure 4, page number 50. ମାଖନପୁରୀ ସମୟେ ଶାବକ ହାର ନକ୍ସା ମେଳକ କରାଯିବାରେ ମେଳ ଥାଇ ହାର ନକ୍ସା ସହିତ ସରଜମିନି ମେଳ ରହିଛି। ରକବା ପାସ୍ କରାଯାଇ ନୋଟ୍ କରାଯାଇଛି ଶାବକ ଅନାବଧି ଥାଇ କିସମ ପତିତ ମାଇ ଲର୍ଡସିପ୍ ଦିସ୍ ରିଫ୍ଲେକ୍ଟ ଦ୍ୟାଟ୍ ଦ କିସମ ଇଜ୍ ପତିତ ଥିବା ହାଲକୁ ତୋଇଳା କିସମ ରହିଛି ଦଖଲକାରୀ ଅନୁପସ୍ଥିତ ଏଣୁ ପ୍ଲଟ ନମ୍ବର ଶାବକ ପ୍ଲଟ ନମ୍ବର 956 ଏତିକିକୁ ଆବାଦ ଯୋଗ୍ୟ ଅନାବଧି ଖାତାରେ ରେକର୍ଡ କରାଯିବା ଆବଶ୍ୟକ ମାଇ ଲର୍ଡସିପ୍ ଇନ୍ ଦିସ୍ କେସ୍ ଦ ପିଟିସନର had challenged the dispute schedule land to record in his name my lordship. But during the period, firstly the lease case should be decided. My lordship, page number 57, para, last para my lordship.
You know, when the revisional authority has held that this is a clear case of disputed fact in page 58,
My
the
lordship,
last operative part,
my lordship,
and proof of title of the suit land and the petitioner does not enjoy sworn, so how this can be adjudicated in a writ petition?
no my lordship, my limited period to direction, the lease case has been pending before the additional Tahsildar, Bhubaneswar my lordship, page number 48.
Which is, what is your prayer?
Direction to the Tahsildar, opposite part number 6, to dispose the lease case matter.
But your prayer is to set aside the order dated.
My
sworn.
lordship,
So that prayer you are not pressing.
my lordship, yes, my lordship.
So you only pray for the second part, to direct the opposite party number 6 Tahsildar to decide WL case number so and so.
My lordship.
WL case has not yet been decided.
No, my lordship. The case has been pending since 2002, page number 44, my lordship.
But the number has been given as 73.
No, my lordship. W case number, my lordship, 160 by 73.
जो देइछन्ति ना
Again.
prayer portion रे लिखिछन्ति WL case number 162 by 73.
My lordship.
73 is the year or not?
Year.
So आपण 2002 रो कोन बुझन्ति?
The case, my lordship, 73 रो जो लीज केस थी जो आवेदनकारी सर्वे कमिटीडा करिथिले ता पेंडिंग रहिछि एडिशनल तहसीलदार माइ लॉर्ड मतलब तहसीलदार पाखरे पेज नंबर 44 माइ लॉर्ड.
You are in a hurry that it should be disposed of early.
No, whatever may be. Not a hurry. Only the ground, my lordship.
Because it is pending for cancellation.
No, my lordship. Only inquiry, my lordship. The incomplete lead is incomplete. Under the
lease is incomplete in the sense you have bought from a person who had got that incomplete lease.
No, my lordship. The division court has no power to decide the lease case and also not to decide the forest land. Only the maintainability.
Maintainability you are challenging where?
Only my direction, only praying for a direction only to dispose the early stage number. So many cases pending, my lordship, before the ADM and also Tahsildar.
So if so many cases are pending, how can we direct for that this case should be disposed of early? There must be a batch of cases. Each number of wasteland lease cases are there pursuant to the order of this court in that 1998 OJC. Number of cases have been reopened and notices have been issued.
My lordship.
So this is one such case.
My lordship.
You order sheet आपण देइछन्ति.
My lordship.
Annexure 3 रे सेटार लास्ट ऑर्डर शीट टा होजी देखंतु.
Put up on 25/6.
Put up on 31/8/2002 page 48 तापर आउ किछ ऑर्डर नाही. काई ऑर्डर से ऑर्डर कोड गला
पेंडिंग my lordship. My lordship, I obtained the certified copy.
सर्टिफाइड कॉपी केबे अप्लाई करछन्ति?
15/11/23.
हां. ये इटा कोन अप टू 3 पर्यंत एमती किन रहिछि?
My lordship.
2002 रो आउ किछ ऑर्डर शीट लेखा ही नहीं.
नहीं my lordship. Only the London Court additional junior additional joint commissioner has also reflects in his order, my lordship, last para page number 57. The view of the standing council was solicited on 26/11/2023. During hearing, the standing council submitted that the suit land was originally a double L case number 162/23, but the rule governing sanction of a lease has not been found in the so-called Wasteland lease, which remains incomplete आज on 25/6/2002, my lord.
You are Mr. Mishra?
No, ma'am.
Then?
I'm the petition. The court reflects in it.
No, you are Mr. Behra?
My lord.
Okay. You have made 2 prayers in your writ petition.
My lord.
You want us to, now you are saying that you don't want to press the first prayer.
Ma'am.
Then what will happen to that order which has been passed against you? My lord, mane kon? Because you are challenging an order which is against you. So if you withdraw means do not press that prayer. Won't you be prejudiced?
Yes, ma'am.
Yes, କଣ ମ? ସେଟା ଭାବିବେନି କି won't you consider ଯେ what will the effect? When you are saying ଯେ ଖାଲି ଆରଟା ଗୋଟେ direction ଦେଇ ଦିଅନ୍ତୁ, you had come up here. Dismissal not maintainable ହେଇଛି. Not maintainable ହେଇଛି on the ground that he has
The petitioner has not submitted the certified copy of the Wasteland lease. It was the pending achieved. Further consideration point order sheet to
yes, instruction to the stage. ଜଣା ନାହିଁ ତ କଣ order ଦବ date fix କରିବ. ନାଇଁ ଏଇଟା ଠିକ ଅଛି, ତେଇଶରେ କିଛି ହେଇନି, but ଗୋଟେ ନେଇ ଆସିଲେ there are number of cases pending. ଗୋଟେ ତାଙ୍କର କଣ ଗୋଟେ ଥିବ ଯେ କାହାକୁ allot ହେଇଛି disposal ପାଇଁ କି କଣ.
All right, this petition has been filed by the petitioner Banamali Rao with a prayer to set aside the order dated 9/8/2024 passed by the opposite party number 2, additional commissioner, additional revision, court number 4, Bhubaneswar. In this number in OSS case number 631 of 2022 by annexure 6. The further prayer for a direction to the opposite party number 6, Tahsildar, Bhubaneswar, beside WL case number 162 of 1973, 162/73 within a stipulated period. The learned counsel for the petitioner has filed the order sheet of WL case number 160/73, which shows that the certified copy was applied. The certified copy of the order sheet was applied on 15/11/2023 and it was delivered on 23/11/2023. And the last order that was passed in the said case by the additional Tahsildar Bhubaneswar is dated 25/6/2002 and on which date notice was issued to the parties and the case was posted to 31/8/2002. And on 31/8/2002, it is mentioned that the case was posted to 39/2002, since the additional Tahsildar is on leave. The learned counsel for the petitioner emphatically submitted that after 31/8/2002, no order has been passed in the said case. Let the Land and Council for the state obtain instruction as to how many WL cases are pending before the additional Tahsildar Bhubaneswar, and why the order sheet after 31/8/2002 has not been maintained. Put up this matter on କେବେ ରଖିବା କୁହନ୍ତୁ? ଏ 31/8/2002 ପରେ 22 ବର୍ଷ ଉପରେ ହେଇଗଲାଣି, ଆଉ ଆପଣଙ୍କର ଅର୍ଡର ସିଟ୍ ବି ଲେଖା ହଉନି।
Page 57 मिलो
ହଁ
page 57 last paragraph
କଣ
page 57 may I read मिलो that view of the standing council जो solicited on 24/11/2023 during hearing the standing council stated that the suit land is originally WL case number such and such, but the ruling government sanctioning the lease has not been found in the so-called Wasteland lease, which remain incomplete on 25/6/2002. The additional Tahsildar Bhubaneswar has issued notice to the resumption of the lease under Section 3B of the Ujjwal Act. The term and tenure of the lease, cost of the lease, etc., are not provided in the resumption case record, which is not completed also. Therefore, it is not possible to examine the legality of the revision petition based on the incomplete lease process, which a resumption has already been ordered by ADM Bhubaneswar. The revision authority to resume the land violated such and such, as mentioned in the order of additional Tahsildar Bhubaneswar dated 22/6/2023.
This is contradictory. He could not have directed for resumption because notice has been issued.
My lord.
So 1999 order must be for issue of notice pursuant to that order in OJC.
My lord. But here they apply the certified copy.
That is all right. So you
That
get
shows that
instruction.
this is the
ଆପଣ ଯଦି କହିବେ ନାହିଁ 2002 ପରେ ଆହୁରି ଅର୍ଡର ସିଟ୍ ଲେଖା ହେଇଛି,
my lord.
ହେଇପାରେ ହୁଏତ ସେ ପର୍ଟିକୁଲାର କେତେଟା ଅର୍ଡର ମାଗି ପାରନ୍ତି।
That's why we wanted to get instructions. And another thing, Mr. Naik, that a number of cases, Mona Ichha delle lease to persons. So rightly, wrongly, they have been granted lease in 72, 76, 80. Thereafter, other people have bought from them. In some, you have given permission, not being aware what is the right thing. They have bought the land, given consideration, and built houses. Now you resume the land, but in the meanwhile, you resume the land. They are not aware. So what is the government proposing to do? Because somewhere in some case I have read that government has set up a committee to consider these wasteland lease cases as well as Jawan lease cases, whether to continue with those cases.
Purchase କରିବେ।
Whatever, how to regularize the what they are being harassed.
free of cost ରେ ଦିଆ ହେଇଛି suppose। ତାଙ୍କର ସିଏ ତାକୁ ବିକି ଦେଇକି ତାର ଯେତିକି ଟଙ୍କା ନବା କଥା ସିଏ ଯବାନ ଅଲରେଡି ନେଇଗଲାଣି।
ଇଏ ଘର କରି ରହିଛନ୍ତି
ଏମାନେ ତା ଘର କରି ରହିଛନ୍ତି। ଯଦି ଆପଣ କହିଥାନ୍ତେ ଯେ ଯବାନ ଯୋଉ ସମୟରେ ନେଲା ସେ ସମୟରେ ତାର ଭ୍ୟାଲୁଏସନ ବା ବର୍ତ୍ତମାନ ତାର ମାର୍କେଟ ରେଟ୍ ଇଏ ଆଉଛି, ତେଣୁ ସିଏ ଯଦି ତାକୁ ଯଦି ଅଫର ଗୋଟେ ଦିଆଯାଆନ୍ତା ଯେ whether he is agree to purchase this land at this price, or ଯେତେବେଳେ ସେ କିଣିଲା, ତେଣୁ ବର୍ତ୍ତମାନ ଟୋଟାଲ ସେ କେମିତି ତାର
15-20 ବର୍ଷ ହେଲା ଘର ତିଆରି କରି ରହିଛନ୍ତି ସେଠି। So you find out. And ଗୋଟେ ଥିଲା somewhere I've seen government had started a scheme, I think committee headed by the member board of revenue or something. ବୁଝନ୍ତୁ।
last order. How many cases have been captivated?
The order of free
copy of the order. Yeah. And 2 weeks further, 7/4/2025.
Item 11.
My lord, item 11, I mean BC, my lord. On behalf of Mr. Bhavan Shankar Mitra, my lord, can you print adjournment? Hospital, my lord. The matter may be taken up on Thursday or in some other day.
My lord, I am appearing for opposite party number 2 in this case. I may be allowed 2 weeks time to file my counter.
अरे he wants time, why should he file counter? ये किए?
I opposite party number 2.
Which case?
11.
11.
11, there is a, in the first date, when it was taken off on 6/3/25, he wanted, the petitioner's counsel wanted that he wanted to carry out some amendment in the post title by filing an interim application. So that perhaps he has not done, or you have done it.
नहीं, not right.
Consolidated post title में the region college.
Without the amendment, consolation, settlement time, whatever. Here, where is Mr. Mahanti? You have filed a consolidated cost title without filing an IA. So you presume that your application will be allowed, or what? I can't understand. There is no IA but a
This big was belongs to Mr. Mishra, my lord. Telephonic call, just his father-in-law was admitted in hospital. My lord, he is going to take 2 days time, my lord.
on ground of illness in his family.
The land counsel for the mention is made on behalf of Mr. Mishra
by Mr.
Abhijit Mahanti for adjournment. Land counsel for the opposite party number 2.
Ajit Patnaik, my lord.
Opposite party number
opposite
party number 2.
Some problem is there.
What problem?
My video is on, my lord. Some problem is there. My lord.
You are appearing for the sub-collector Sundargarh?
My lord, that has been wrongly mentioned. Sub-collector Sundargarh, it is sub-collector Panpos.
So you are appearing for the sub-collector Panpos?
Panpos.
How can you appear for the government officer?
My lord, he is the land acquisition officer.
So that unless it is amended, you cannot appear.
He is the land acquisition authority. That's why they have assigned me to appear on their behalf.
You might have filed a consolidated Who has filed the consolidated? The member for the Yeah, Mr. Ajit Mahanti.
Ajit Patnaik, my lord.
Ajit Patnaik.
Okaratnama. I have filed Okaratnama.
Yeah.
Two and three suppletant there.
Consolidated post title is listed in sub-collector on
CLA.
Panpos locality, and he is appearing for that. Party number 2. Amendment petition filing without file provision consolidated post title.
Item 12.
Obligation.
The annexed one pending before the option number 3. For the apportionment of the compensation you'll see. The reference is pending for annexed one. 64 is exactly the collector is of the condition. Pending into appeal number 3, Your Lordship. Litigation officer Hon'Ble.
64 million. For the right to fair compensation. Reference to authority. Any person who was not accepted the award may.
Compensation.
Provision. Award of lesson.
Compensation of compensation distribution of the compensation, the apportionment of compensation, section 30.
And was acquired by the MCL authority in 1987. So what
Para second
according to the awards from
1894 Legislation Act. Dispute asset. Next one will see. The present petitioner, sir. Present petitioner, sir. Present petitioner, sir.
Where is the signature? On whose LTA it is? LTA ନାହିଁ LTA କାହାର attested ହେଇନି ଯୋଉମାନେ କରିଛନ୍ତି ଦରଖାସ୍ତ ଦେଇଛନ୍ତି ତାଙ୍କର ଦସ୍ତଖତ ନାହିଁ ୟାର ମୂଲ୍ୟ କଣ? This petition has been filed by petitioner so with a prayer for a direction to the land acquisition officer Sundargarh, bracket opposite party number 3, to take a decision on the application filed by the petitioner under Annex 3 regarding a reference of the dispute with regard to apportionment of the compensation for the acquired land under Khata number so within a stipulated period. The prayer is made in the application to make the reference under section 30 of the Land Acquisition Act. However, it appears that nobody has signed the application, even though in the first page of the application, the name of 5 applicants are there. Stop. one LTA has been given in page 2, but it is not mentioned whose LTA it is and who has stopped. In view of the state of affairs, the Land Council for the petition seeks permission to withdraw this writ petition. Accordingly, the writ petition is disposed of as we can. He wants to file a proper application before the concerned authority. Accordingly, disposed of as we can.
LTI টা page number 9 রয়েছে LTI টা page number 9
Page number
9 রয়েছে
LTI টা can be LTI of so and so.
page number 9 the LTI টা আছে
Page number 2 of the application. It's a running page. Your application consists of how many pages? 3 pages.
3 pages. Page number 2.
Yes.
Yeah, Mr. Panda. না লিখে দেবে আছে তাহলে পাওয়ার আছে
T Panda.
Item 13.
May I please? The petitioner is challenging the heinous action of the opposite party authorities in constructing the government road over the private land of the present petitioner and other lordship and encroaching the same for the purpose of road lordship. Lordship, kindly have a glance annexure 1 series page 14 lordship. The land is recorded 2 ROR I have given a lordship. One is page 14 lordship, that is Subhash Chandra Sahu, the present petitioner, and other brothers lordship. One brother is there. And the page 16 is the ROR lordship where the Kartika Sahu and others, that the name of his father is the late father Achyuta Sahu is their lordship. And out of these two Khatyana lordship, in first ROR page 15, 2 plots are there lordship. Page 15, plot number 2036 by 3889 and plot number 2037/3890. These 2 plots, and in the second ROR lordship, page 17, 4 plots are there lordship. Out of 10 plots, 4 plots have been imposed by the government lordship while constructing the road lordship. Without any land acquisition process, without identification of the land, and without any consent, without any compensation, the road is constructed in view of the work order issued under Annex 2 LRC. And we have repented to the authorities under Annex 3 page 20 LRC. And in spite of repentation LRC, they are, without considering the repentation, they are going on construction of the road LRC.
Representation କେବେ ଦେଲେ?
20 ଫେବୃଆରୀରେ ଗୋଟେ 10 ତାରିଖରେ ଦେଇଥିଲେ। 10
ରିପ୍ରେଜେଣ୍ଟେସନ ଯୋଉଟା ଆନେକ୍ସ କରିଛନ୍ତି କେବେ ଫାଇଲ ଦେଲେ?
10/2/25 ରେ ଗୋଟେ ଦେଲେ, ତାକୁ ମେଲ ଦେଇଛନ୍ତି।
ରିପ୍ରେଜେଣ୍ଟେସନ ଡେଟଟା 20/2/2025 ରେ ଫାଇଲ କରିଛନ୍ତି। ରିଟ୍ ଟା କେବେ ଫାଇଲ କଲେ?
ସପ୍ତାହ ପରେ, କାରଣ ସେମାନେ କନଷ୍ଟ୍ରକ୍ସନ କରି ଚାଲେ 3 ତାରିଖ ଫାଇଲ ହେଇଛି ରିଟ୍। 10 ତାରିଖ ଆଗେ ଜଣେଇଲେ, ଯୋଉଟା ଦେଇଛି ପେଜ 21 ରେ, ଏଣ୍ଟାର ଭିଲେଜେସ୍ ଯାହା ଯାହାର ସବୁ ଜାଗା ଯାଇଛି ସମସ୍ତେ ସିଗ୍ନେଚର କରିକି ଜଣେଇଲେ 10/2/20 ରେ। ତାପରେ ସେଟା ମେଲ ରେ ସବୁ ଅଥରିଟିଙ୍କୁ ପଠେଇଛନ୍ତି ଫେବୃଆରୀ 20 ରେ।
No, ସେ particular ତାଙ୍କରି land ଟା, ଏଇ ଯୋଉ ଲୋକଟାର ସୁଭାଷ ଚନ୍ଦ୍ର ସାହୁର ଦେଖିଲେ ପରା ସେ ଦେଖୁନାହାନ୍ତି। ସୁଭାଷ ଚନ୍ଦ୍ର ସାହୁର annexure 1 ରେ ହତିଆଣ୍ଡାରେ ତାର ନାଁ ଅଛି, ତାର ଯୋଉ ଜମି ଦିଟା ଯାଇଛି ରୋଡ କନଷ୍ଟ୍ରକ୍ସନ ହେଇଛି।
କପି ପେଷ୍ଟ କଲା ବେଳକୁ ପିଏଲ ଲେଖିଛନ୍ତି ଆଉ
ସେଟା
Not only to the annexure 3, the number of also.
no, only in respect of ସୁଭାଷ ଚନ୍ଦ୍ର ସାହୁର ରହୁଛି।
So, no, all these plots are all your plots.
Yes, LRC. With my family, I am one of the shareholder. First plot, first ଖାତାରେ ମୁଁ ଆଉ ମୋର ଭାଇ, ସେକେଣ୍ଡ ଖାତାରେ ବାପା ଆଉ ବାପାଙ୍କ ଭାଇ ମାନେ।
your family ଜାଗା
ମାଇନର୍ସ।
ବାପା
I am one of
ବାପା
the
ଭାଇ,
ବାପାଙ୍କ ଭାଇ ମାନେ ସବୁ। ଅଚ୍ୟୁତ ସାହୁ।
ବାପା ନାହାନ୍ତି।
No, LRC.
The signatory to annexure 3 is different number of persons of the villagers, not belongs to the
No, but signatory 10 is my signature.
ନାଇଁ,
10
ନାଇଁ,
have line.
ସେ ଯୋଉ ରିପ୍ରେଜେଣ୍ଟେସନ ଦେଇଛନ୍ତି ସେଟା ତ 30ଟା ଲୋକ ବୋଧେ ଦସ୍ତଖତ କରିଛନ୍ତି।
ଆଜ୍ଞା ସେମାନଙ୍କର ସମସ୍ତଙ୍କର ଜାଗା ମାଡିକିରି
ସେଇ ତ
ରାସ୍ତା ହଉଛି।
ତ ହି ଇଜ ପଏଣ୍ଟିଂ ଆଉଟ୍ PIL ବୋଲି।
ନାଇଁ I am concerned to my land LLC.
ଗୋଟେ ରିପ୍ରେଜେଣ୍ଟେସନ ଦେଇଥାନ୍ତେ ଆପଣଙ୍କ ଲ୍ୟାଣ୍ଡ ଅନୁସାରେ।
ସେପାରେଟଲି ଦେଇନାହାନ୍ତି।
ହେଲେ ସୁବିଧା ହବ। They will
Yes, yes,
consider, you
yes,
will have a
fine.
grievance, you can approach।
Yes, sir.
ମୁଁ ଗୋଟେ ଦେଇଦେବି, ଦେଇଦେଲେ better ହବ।
ଦେଖନ୍ତୁ this writ petition has been
ସେଇଟା ଜଣା ପଡୁଛି ଯେ ଏତେ ଲୋକ ତ
filed by the petitioner Subhash Chandra Sahu with a prayer entirely according to for a direction to the opposite party number key representation disclosure karibo 2 opposite party number 2 collector Dhinkanas to dispose of the representation dated 20/2/2025. The learning counsel for the petitioner pointed out the averments taken in the
କୋଉ paragraph କହିଲେ?
writ petition, paragraph 5B
3A
3A.
Yes, sir. 3A land.
along with others। ये कौन?
3E कर दिया 3E रे कर दिया page 8 रे 3 रे
ସେଟା page 8 ରେ ଲେଖିଛନ୍ତି।
Page 8 ରେ?
हाँ
ground
that the opposite party authorities are constructing the proposed road under annexure 2 by encroaching over the private plot number so and so।
ଆ ଭିତରୁ କୋଉ ପ୍ଲଟ ଆପଣଙ୍କର? ଦିଟା ଆଗ ନାଇଁ ପରା।
ଫାର୍ଷ୍ଟ ଖାତାରେ 2ଟା ସେକେଣ୍ଡ ଖାତାରେ 4ଟା ସେଟା ମେନସନ କର।
belonging to the petitioner କୋଉଠି ଲେଖିଲେ? private plot
এটা হচ্ছে annexure 1 ବି ଜଣା ପଡିବ ତାର
ପ୍ରାଇଭେଟ ତାର ଏବଂ ସମସ୍ତଙ୍କର ଉପରେ ଲେଖିଛି।
ସମସ୍ତଙ୍କର ବା
ନାଇଁ ଏଇ ଯୋଉଟା ଦିଟା କହିଲେ ଆପଣ
ନାଇଁ 2ଟା ପ୍ଲସ ଆଉ 4ଟା 6ଟା।
ହଁ ସେଇ 4ଟା ଯାକ ଆପଣଙ୍କର ମିଶିକିନା ଅଛି।
Yes, LRC, one of the co-sharer.
ସେଟା କଣ?
The copy of the record of rights have been annexed to the writ petition as annexure 1 series. However, on looking at the representation dated 20/2/2025, it appears that apart from the petitioner, there are other signatories to the representation. Considering the submission made by the land counsel for the respective parties, to dispose of the representation directing the opposite party to this representation under annexure 3 to be that of the petitioner so far as his lands under annexure 1 series pertaining to so and so is data plot like that and one of the co-sharers in land pertaining to data plot like that and dispose of the representation within so and so period date delivery from the date of production of the certified copy. We have not expressed any opinion on the merits and communicate the order to
ଗୋଟେ ଲାଇନ୍ କହିଛନ୍ତି grievance of the petitioner regard acquiring the land they are constructing road।
ଆସିବି ଭାଇ ପାରାଗ୍ରାଫ ରେ ଆମେ ଯୋଉ ପଢିଲି ତା ଦେହରେ ଲେଖା ହେଇଛି 8 number paragraph page ରେ ଲେଖା ହେଇଛି ଲେଖିଲେ ନା the authorities are constructing the proposed road under so and so by encroaching the private plot number page 8 ରେ ଲେଖା ହେଇଛି।
Till then LRC
compensation to private till then on representation disclosure. Yes, next.
I will pardon my lord.
Item 1 का मतलब तुरंत whereabouts କିଛି ମିଳୁନି। So last boarded 3-4 times, maybe more than that, instruction mobile and I have also tried on my side.
Two instructions regarding that even IO and the wherever the IO is valid, he has declared and his valid is contact number is discussed. And so that the present who is concerned petitioner, wherever it is not.
IO alive संगे कौन?
Last occasion में मालूम कौन सा यदि आयोग करो यदि re-examine करने पर माने further evidence आयोग करो नबा में
We come to the order dated 21/11/2023. 21/11/2023.
Madam. Councilman Board is satisfied that as per order dated 5/10/2023, they have received the copy of the agreed one. So also answer and self statement of the deceased. Declared by the investigation officer on 22/10/2006. Press miscellaneous additional council, however, submitted communication has been made to ascertain where the investigation officer is alleged or not, but he has got some information that the whereabouts of the appellant is not known and he seeks some further time to that respect. That the matter will be listed on 11 Region 2023.
No, we are not concerned about this IO. IO's requirement would see you 161 the record per slab that is to be utilized as dying declaration or not. That's a different aspect. Question is that we wanted to know on that day whether the appellant is alive or dead.
That
ସେତିକି ଆପଣଙ୍କୁ କହିବାକୁ ହବ, otherwise you will hear the matter.
ଗୋଟେ instruction ବି ସେ ଆସିଥିଲା 29/9/2023 ମୋ ପାଇଁ ଗୋଟେ ଅଛି କପି ତାର।
The judgment was pronounced, you see, on 2007, 29th November 2007, and the age that has been reflected in that judgment, is it either 51 years or something?
31.
31. So, and he was 31 mane semti kichi adhika he jaye, but he was directed to be released on bail by this court. That was on 16/12/2011.
So you are the counsel appointed by the court, or he has engaged you?
He had engaged me.
So you don't have any contact with him since when?
No.
Since when?
Since right, 24-25 रे try करनी, but 24 रे try करथलु last.
मैंने last केबे contact थिला 2011
2020 ना last कोना सेमति तो last contact bail हला परठु तापस
that is why that was 2000 that was 2011
हां matter list हला पर for hearing out रे I think 2023 रे I tried to contact
ता माने 2011 ପରେ no contact
because he since after he has not returned to the said village, nobody in the locality could be able to tell his
then सेटा who's telling
एटा गोटे IAC report थला 29/9/23
You see, the thing is that suppose we allow the appeal, then there is no question. If we dismiss the appeal, so obviously that is to be cancelled. Bail bond and non-bailable warrant issue. जेबे जदि बंचिथिबो arrest हेबो तरे why this hearing would be delayed?
खाली इतना whether if he is alive something then that makes sense.
For that we cannot adjourn the matter for indefinite.
Lordship says
now what is the last report of the IO?
16/2/2025.
What is the report?
Last occasion I was also giving that report.
नहीं last occasion माने 5/2 रे उठला पर 16/2 रे आपण केन देले
अपन रिपोर्ट अछि तो कॉपी उडे दोना
5/2 रे लिस्ट है आपण रिपोर्ट 16/2 देले कोड
Then we have not returned back to be said.
नहीं keep it. नहीं keep it. ओहो बेल जाइछि ना नहीं
हाँ
ना बेल आमे अलाउ कलु जाइछि कि नहीं से कहबो बुझिए तो बुझंदी जो जेल गला तापर तो सुनाने नहीं जेल रू बुझिया दरकार रिलीज ହେଇछि कि नहीं
filed wakalatnama. It was a jail criminal appeal, na?
again
So when you file your wakalatnama,
HP Das was engaged initially
you see your second wakalatnama से बाहर हुआ already बाहर है इस तरह.
नहीं 24/3/2009 रे वकालतनामा ଦେଇଥିଲେ नहीं 24/3/2009 रे ଗୋଟେ କଣ ନୋଟିଂ ଅଛି
ଆଉ 24/2/2009 ବୋଧେ
24/3 ରେ ତା ଡିସେମ୍ବର ହେଲେ ଶାଶ୍ୱତ ପଟ୍ଟନାୟକଙ୍କର ଆକ୍ସେପ୍ଟ ହେଲା
24/2/2009 ଆଉ ଗୋଟେ 7/8/2008 ସେମ୍
ହେଲା ନା ହେଲା ବେଲ ଯାଇଛି ନା ନା ଜେଲ ରୁ ବିଲ୍ କେଟା ରିପୋର୍ଟ
ସିଏ କହୁଛନ୍ତି
ବେଲ ଯାଇଛି
କହିଲେ ପୁରା 2023 ରେ
ବେଲ ବେଳକୁ ଫାଇଲ ରେ କିଛି ନାହିଁ ଅର୍ଡର ନେଲା କି ନ ନେଲା ଫାଇଲ ଟା ହିଁ ହଜି ଯାଇଥିଲା ମୁଁ ଯାହା ବି ଶୁଣୁଛି ଜେଲ ରୁ ରିପୋର୍ଟ ଆଣିକି ରିଲିଜ ରେ ଯାଇଛି ଗୋଟେ one should get something at least ଇଏ କହୁଛନ୍ତି ଜେଲ ଗଲା ବେଳେ ଖବର ନାହିଁ ରିଲିଜ ହେଇଛି କି ନାହିଁ ଡାଉଟ କରୁଛି
next week so that we can call the jail IAC ଦି ଜଣ ବି ମାଗିଲେ
ଆଇଆସି କୁ ଆଉ କଣ ମାଗିବେ
IAC ତ ସେତିକି ଦଉଛନ୍ତି
ସେ ଗାଁର ବୁଝିଲା କହିଲା ଜେଲ ଗଲା ପରେ ଆଉ ଆସିନି ପରା ସେ ଜେଲ ରୁ ଖାଲି ଗୋଟେ ରିପୋର୍ଟ ନେଇ ଆସନ୍ତୁ ସେ ଯାଇଛି ବୋଲି ଜେଲ ରୁ ଯାଇଛି ବୋଲି ଯାଇଛି ତ ନିଶ୍ଚୟ ନହେଲେ ନିଶ୍ଚୟ କେମିତି ଭିତରେ ରହିକି ଯଦି ଇଏ ହେଇଯାଇଥିବ କିଛି କମ ପିରିୟଡ ନାହିଁ 14 ବର୍ଷ ହେଲାଣି ଦେଇଥିଲା
ଷୋହଳ ବାର 2011 ରେ ଆଲାଉ ହେଇଛି
You know that ସେଟା ତ ଅର୍ଡର ଅଛି 25/7/23 ନାଇଁ we are asking in view of the report of that IAC the inquiry revealed that after he was sent to jail there is no information
the order dated 25/7/23 there it is mentioned that the appellant has been released on bail since 16th
December 2011
that is that
the IAC of the concerned police station will submit a report before the next date of this court for the present whereabouts.
It should have been granted bail instead of released on bail granted bail ହେଇଥାନ୍ତା ମୁଁ ବି ସେଇଆ ଭାବିଲି
released from custody furnishing bail bond ଏଇ type of clarity ନାହିଁ ସେ order ଟା
because କିଛି ତ instruction ନାହିଁ
which jail he was there that point of time
you can keep it on Thursday also you can find out
এটা wakalatnama ରେ ଦେଖଉଛି
assistant
special jail
ମ୍ୟାଡାମଙ୍କ ये तो जो ଦେଇଛନ୍ତି ତା ଦେହରେ ଜେଲ ର ଷ୍ଟାମ୍ପ ନାହିଁ। 2008 ଜେଲ ର ଷ୍ଟାମ୍ପ
ଏଇଟା 24/2/2009 ଯୋଉଟା ମୁଁ ଫାଇଲ କରିଛି ସେଥିରେ ଅଛି।
ହଁ
ଯୋଉଟା ମୁଁ ଫାଇଲ କରିଛି ସାଇନ୍ ଆଣ୍ଡ ଆଟେଷ୍ଟେଡ୍ 24/2/2009 ରେ ଆସିଷ୍ଟାଣ୍ଟ
ଏଇଟା ତ ଫାଇଲ କରିଛନ୍ତି ଆପଣ
24/2/9 ରେ।
ତା ପରଟା ଆଚ୍ଛା ଏଇଟା ଆଗ ସ୍କାନିଂ ହେଇଛି ସେଟା ପରେ ସ୍କାନିଂ ହେଇଛି।
ବ୍ରାହ୍ମଣପାଳ ରାଉରକେଲା ଜେଲ।
The one which is dated 7/8 has been filed in February. The one which is dated 7/8/2008 has been filed in February. So that is why it is kept below the other one. This is March. କଣ ଏମିତି ହେଇଛି? ଏଟା ମାର୍ଚ୍ଚ 2009 ରେ ଫାଇଲ ହେଇଛି। ତ ଏଇଟାରେ କୋଉ ଜେଲ? ସ୍ପେଶାଲ ଜେଲ ରାଉରକେଲା। ସ୍ପେଶାଲ ଜେଲ ରାଉରକେଲା।
So, take instruction, we can take it this during course of this week. This is already there in the list. This much of information, whether he has been furnished bail bond and released from custody or not. Hala, therefore we can hear the matter because it should have to place away you order ta. Whereabouts not known.
ଏଇଦିନ ବେଲ୍ ଗ୍ରାଣ୍ଟ ହେଇଥିଲା whether he has been released on bail. ସେତିକି ତ ପଚାରିବାର ଅଛି ଆଉ।
In writing ନେଇ ଆସନ୍ତୁ କାରଣ ସେମାନେ ତ ଅବିକା ଫାଇଲ ବି ସେ ପଳେଇ ଆସିବେ କିନ୍ତୁ ସେମିତି ଇନଫର୍ମେସନ ଟା ଠିକ ହବନି। We want it writing that ସେଠି ମେନସନ ହଉଥିବ ନା ଏଇ ଦିନ ସେ ବାହାରିଲା ହଁ take down
ହିୟରିଂ ଡେଟ୍ ଟା ବି ଫିକ୍ସ କରିଦବା।
ସେ ରିପୋର୍ଟ ଟା ପଳେଇ ଆସୁ ଗୁରୁବାର।
Let it be in the list. ଅର୍ଡର ଟା ଯଦି ହବ ତାହେଲେ ସପ୍ଲିମେଣ୍ଟାରୀ ଲିଷ୍ଟ।
ହଁ ସପ୍ଲିମେଣ୍ଟାରୀ
ଆଉ ଗୋଟେ ପ୍ରେୟାର ଥିଲା ଖାଲି ଟିକେ ପେନ୍ ଡ୍ରାଇଭ୍ ରେ ନେଇଥାନ୍ତେ।
ହଁ ନେଇଯା ଲେଖି ଦଉଛୁ। The Learning Council for the state has produced the report dated 16/2/2025 of IIC Brahmanicharam Police Station, Raurkela, from which it is mentioned, that the appellant from the inquiry, it revealed that the appellant was taken into judicial custody in connection with the murder of his wife, and since then he has not returned back to the village. Stop. Nobody in the locality could able to tell his present whereabouts. Stop. Further inquiry has been made that the investigating officer, Sri Jay Krishna Patel, a retired inspector of police, is alive and he is residing in his native village. Stop. It appears that the appellant was directed to be released on bail in miscase number 124 of 2011 by order dated 16/12/2011. However, there is nothing on record as to whether in terms of the bail order dated 16/12/2011 he furnished the bail bond and released from jail custody or not. Let the Learning Council for the state take necessary instruction to the superintendent of the concerned jail as to whether the appellant furnished the bail bond and released from custody or not. Put up this matter on 20th of March 2025, a free copy of the order be handed over to the Land Council for the state in writing করতে হবে, যে instruction টা under in writing. আচ্ছা, এই যে written instruction টা taken on record করতে হবে। Yes. And Mrs. Shashwat Patnaik, Land Council, appearing for the appellant.
Pen drive কথাটা reflect কর।
Mrs. Patnaik submits that you have received the paper book.
I don't have knowledge.
Then a copy of the paper book will be furnished to you. So, submit that she is not having a copy of the paper book. Let the paper book copy be supplied to during course of the remodeling the event right now.
How do we pen drive এর থেকে postmortem report করে
you want the, if you want, we can give you the exhibit list.
Exhibit
That
list.
This is base for supply of the
161 or exhibit list.
all the exhibits and also the 161 statements of the witnesses. This can be supplied in the contents will be produced by the
ଯଦି ନଥିବ paper book ରେ ତ ନଥିବ postmortem report. Postmortem
paper
report
book ରେ postmortem report ନଥାଏ, ବେଳେ ବେଳେ ଥାଏ, but otherwise not.
deposition report ତ ଥିବ।
A evidence of doctor ଥିବ, but you take it. Apart from that, other exhibits ଗୁଡାକ ମଧ୍ୟ these cases are actually most likely the dying declaration based conviction. It's a case of bride born. Yeah.
Item 2.
Lordship, in this case, appellant has been convicted under section 302 IPC, Lordship. And Lordship, the husband killed the wife and no eyewitness. And conviction.
Just.
Custody since
More than 20 years.
more than 20 years. Hearing time only, not hearing it.
Goal application was never moved.
No, they don't.
No, hearing is. Hearing is a well.
Please come to the
Paragraph.
no, you come to the first information report.
महाशय ମୁଁ ଭକ୍ତରାମ ପୂଜାରୀ
Please wait. Yes.
महाशय ମୁଁ ଭକ୍ତରାମ ପୂଜାରୀ ପିତା ହେଲେ ସଦାଶିବ ପୂଜାରୀ ଗ୍ରାମ
Bhaktaram Pujari PW କେତେ?
PW 1 ଲଢୁଛି ଅଛି
PW1. Yes.
ଗ୍ରାମ ବେଦାଗୁଡା ଥାନା ମୁଦିଲପଡା ଜିଲ୍ଲା ମାଲକାନଗିରି ଲେଖି ଦାଖଲ କରିବା ରିପୋର୍ଟ ଏଇକି ଗତକାଲି ତା 10/9/2006 ତାରିଖ ରବିବାର ରାତ୍ର ପ୍ରାୟ 7 ଘଣ୍ଟା ସମୟରେ ଆମ ବେଦାଗୁଡା ଗ୍ରାମ ନିବାସୀ ଭଗବାନ ନାୟକ ପିତା
Bhagavan Naik is the appellant.
ପିତା ଲେଟ୍ ସମରୁ ନାୟକ ତାର ଭାର୍ଯ୍ୟା ରାଧିକା ନାୟକର ଚରିତ୍ର ପ୍ରତି
Radhika Naik is the deceased.
wife of the ଭଗବାନ
There are two deceased, Radhika Naik out there infant.
infant ପଛରେ
ତା ପାଇଁ
ଆସିବ
charge saying and ଦିଟା death ହେଇଛି. Wife and child.
infant ଯୋଉ disease ଯୋଉ ମରିଛି ସେଟା appellate ମାରିନି ସେ ମା କୋଳରୁ ହାତରୁ ଗଳି
Just a minute.
ରାଧିକା ନାୟକର
The charge is
In respect of the wife
commission of
only.
murder of the wife
only.
Radhika Naik, right? Please.
ରାଧିକା ନାୟକର ଚରିତ୍ର ପ୍ରତି ଅକାରଣରେ ସନ୍ଦେହ କରି ରାଧିକା ନାୟକକୁ ଚଢାଉ ପୂର୍ବକ ଧାରୁଆ ଟାଙ୍ଗିଆ ସହ 5-6 ଚୋଟ ଟାଙ୍ଗିଆରେ ପ୍ରହାର କରିବା ଫଳରେ ରାଧିକା ନାୟକର ମୁଣ୍ଡ କାନମୁଣ୍ଡା ପିଠିରେ ଗଭୀର ରକ୍ତାକ୍ତ ହୋଇ ରକ୍ତ ଜୁଡୁପୁଡୁ ଅବସ୍ଥାରେ ଉକ୍ତ ଅପରାଧୀ ଭଗବାନ ନାୟକର ଘର ଅଗଣା ସାମ୍ନାରେ 20 ଦିନର ଛୋଟ ପୁଅ ଶିଶୁ ସହିତ ମରି ପଡିଛି ବୋଲି ଆମ ଗ୍ରାମର ଭାଗୀରଥୀ ନାୟକ ପିତା ଭୀମା ନାୟକର ପାଟିରୁ ମୁଁ ଖବର ଶୁଣି ସଙ୍ଗେ ସଙ୍ଗେ ଘଟଣାସ୍ଥଳକୁ ଯାଇ ଦେଖିଲି ଯେ ରାଧିକା ନାୟକ ଓ ନବଜାତ ଶିଶୁ ପୁଅ ଗଭୀର ଆଘାତପ୍ରାପ୍ତ ହୋଇ ଅଗଣା ସାମ୍ନାରେ ମରି ପଡିଥିଲେ ଏବଂ ରାଧିକା ନାୟକର ସ୍ୱାମୀ ଉପରୋକ୍ତ ଭଗବାନ ନାୟକ ଟାଙ୍ଗିଆ ଧରି ବାଡ ପାଖରେ ଛିଡା ହୋଇ ପାଟିତୁଣ୍ଡ କରୁଥିଲା। ଏହି ହତ୍ୟା ଘଟଣା ନିମ୍ନ ଲୋକମାନେ ଦେଖିଛନ୍ତି। ଭଗବାନ ନାୟକଙ୍କର ଏଭଳି କ୍ରୂରତା ଏବଂ ବର୍ବରୋଚିତ ଓ ଜଘନ୍ୟ ଅପରାଧ ଜନିତ ମନୋବୃତ୍ତି ଓ ହୀନ କାର୍ଯ୍ୟକଳାପ ପ୍ରତି ମୁଁ ଏବଂ ଆମ୍ଭ ଗ୍ରାମବାସୀ କ୍ଷୁବ୍ଧ ହୋଇ ଆମ ଗ୍ରାମରେ ଏ ଘଟଣା ନେଇ ଏକ ପଞ୍ଚାୟତ ଡକାଇ ଦୁର୍ବୃତ୍ତ ଭଗବାନ ନାୟକଙ୍କୁ ପଚାରି ବୁଝିବାରୁ ମୋର ମାଇକିଣା ରାଧିକା ନାୟକର ଚରିତ୍ର ଓ ଗତିବିଧି ଉପରେ ମୁଁ ସନ୍ଦେହ କରି ରାଧିକାକୁ ଟାଙ୍ଗିଆରେ ହାଣି ମର୍ଡର କଲି ବୋଲି ସେ ପଞ୍ଚାୟତଦାର ସମ୍ମୁଖରେ ନିଜର ଦୋଷକୁ ସ୍ୱୀକାର କଲା। ପ୍ରକାଶ ପାଉ କି କାଲି ରାତ୍ର ବର୍ଷା ହେବା ଯୋଗୁଁ ଘଟଣାର ସଙ୍ଗେ ସଙ୍ଗେ ମୁଦିଲପଡା ଥାନାରେ ରିପୋର୍ଟ ଜଣାଇ ନପାରି ଆଜି ଅର୍ଥାତ୍ 11/9/2006 ତାରିଖ ଦିନ ଉକ୍ତ ହତ୍ୟା ଘଟଣା ଆପଣଙ୍କୁ ଏହି ଲିଖିତ ରିପୋର୍ଟ ମାଧ୍ୟମରେ ଜଣାଇ ବିନୀତ ପ୍ରାର୍ଥନା କରିକି ଘଟଣାର ତଦନ୍ତ ପୂର୍ବକ ଅପରାଧୀ ଭଗବାନ ନାୟକର ବିରୋଧରେ ଆଇନଗତ କାର୍ଯ୍ୟାନୁଷ୍ଠାନ ଏବଂ ଉଚିତ ଶାସ୍ତି ବିଧାନ କରିବା।
Okay, you come to the charge that is at page 31. Charge page को पढ़े आसुंतु page 31.
May I read?
Just you on 10/9/2006.
That you on 10/9/2006 at about 7 p.m. in his house situated in village Pedaguda committed a murder by intentionally causing the death of your wife Radhika Naik and thereby committed an offence punishable under section 302 of the IPC and with in my cognizance.
Okay, so whether it is a case based on direct evidence or circumstantial evidence.
No, let's see the only confession and leading to discovery.
ପ୍ରଶ୍ନଟା ଟିକେ ଶୁଣନ୍ତୁ ବୁଝନ୍ତୁ ଉତ୍ତର ଦେବେ। ଏ କେସ୍ ରେ ଆଖି ଦେଖିଲା ଭଳିଆ ସାକ୍ଷୀ କିଏ ଅଛନ୍ତି?
No, no eyewitness.
No eyewitness. ତାପରେ circumstantial evidence ର ଯଦି କେସ୍ ହେଲା କଣ circumstance ଆପଣଙ୍କ against ରେ ଅଛି ତାପରେ ଆମେ ଯିବୁ evidence କୁ। What are the circumstances? कौन अच्छी prosecution case होंगे?
Prosecution case only leading to
माने summed up ହେଇଛି judgment रे जे these are the circumstances which are appearing against you डिस्कशन है सर्कमस्टांस गुड़ा गोटे जगार लेखा है এই circumstance গুড়াক ଅଛି এইটা proof এইটা not proof তারপরে chain is complete নাই আচ্ছা then all right then you read one by one we'll see that PW1 को আসুন page 35
PW1.
Yes.
I know the deceased Radhika. The accused is her husband. They are my co-villagers. The deceased died about 2 years back. About 2 years back, just before the Dasara during evening hours, Moti Naik and Bhagirathi Naik of our village came and told me that
Who are those Moti Naik and Bhagirathi Naik?
villager.
Oh, PW कथा कहूँ ये मैंने examine ही चंदी की
It has not been
No, Moti Naik not.
Moti Naik examine ही ची
No.
Bhagirathi
Bhagirathi Naik examine ହେଇଛି
ହେଇନି ତ
ହେଇଛି Bhagirathi
କେତେ number साठी କୋଉଠି ସାକ୍ଷୀ
ନାଇଁ ଲର୍ଡସିପ ଭାଗୀରଥୀ କିଛି ହେଇନି
page 20 ରେ ଅଛି list of witness ଦି ଜଣ ଯାକ ହେଇନା ହଁ ତାପରେ କୁହନ୍ତୁ ଆପଣ
Bhagirath Naik and came and reported that the accused had killed the deceased by
who reported अछि
Lordship, sorry, Lordship,
why are you in a hurry you are arguing a 302 case madam
Lordship,
don't be in a hurry yes
Lordship. Bhagirath Naik of our village came and told me that the accused Bhagavan Naik had killed his wife by means of Tangia. Hearing the news, we rushed to the house of the accused and found the deceased lying dead on the front veranda and found the bleeding injuries on her neck, back, side of neck and waist. The panchayat meeting was held in the village the same day. The accused was called to the meeting. On being asked, he confessed before everybody that he suspected his wife of infidelity and since he has killed her by a tangia. Thereafter, we went to the police station and lodged the affair, which was scribed by one Shambhu of Mathili. I have put my signature on the affair. Exhibit 1 is the affair. Exhibit 1 by 1 is my signature there. The scribed Shambhu also had signed on the affair on the bottom. Exhibit 1 by 2 is the signature of Shambhu. After scribing the affair, it was read over, explained to me, and on knowing the contents to be true and correct, I put my signature on the affair. Let's see cross-examination. When the meeting was held, the accused was hiding. Meeting was held on southern tanda of our village. The accused and the deceased were living together peacefully. It is not a fact that the accused did not confess his guilt.
So this witness is the informant. He is a post-occurrence witness. He has stated about the confession made by the appellant in the village meeting, right? That is his evidence.
Lordship cross-examination से कहते हैं सेटा hiding लुच्ची थिला meeting के आसीनी बोली.
When the meeting was held,
आसीनी बोली को
the accused was hiding. He was called to the meeting. The meeting hela bale uthi when the meeting was held, the accused was hiding. Mane meeting was held on so and so. What is your argument?
Lordship, prosecution 2 रे कहते से पुलिस आगे कन्फेस करिछि बोली.
No. Meeting जो PW1 ro evidence is relevant because he has stated that a panchayat meeting was held and accused was called and there he confessed before everyone that since he suspected his wife about the character and he killed the wife. So that is his evidence in the chief.
Lordship.
what have you elicited in the cross-examination except this one line that when the meeting was held, the accused was hiding? What does it mean by hiding? ଓଡ଼ିଆରେ କହିଲେ ତାକୁ ଟ୍ରାନ୍ସଲେଟ କଲେ ଯେତେବେଳେ ମିଟିଂ ହେଲା ଆକ୍ୟୁଜ ସେତେବେଳେ ଲୁଚିଥିଲା ଲୁଚିବା ଜାଗାରୁ ତାପରେ ଡକା ହେଲା ସେ ଆସିଲା ଏବଂ ଆସିକିନି କନଫେସ କଲା ତ ଏଇଟା ଏଇ ଗୋଟେ ଲାଇନ ବାହାର କରିଦେଲେ ଯେ ଚିଫ ଏକ୍ସାମିନେସନ ଲାଇନଟା ଗୋଟେ ଅବିଶ୍ୱାସ ହେଇଯିବ ସେମିତି ତ ହଉନି ଏଥିରେ ଘଟଣା ପରେ ସେ ଲୁଚିଥିଲା ତାପରେ ପଞ୍ଚାୟତ ମିଟିଂ ହେଲା ପଞ୍ଚାୟତ ମିଟିଂ କୁ ତାକୁ ଡକା ହେଲା ପରେ ସେ ଆସିଲା ଆସିକିନି ଏଇ ଘଟଣାଟା କହିଲା confession. Question is that whether it would be a voluntary one or not. That is another aspect, because if it is a village meeting and law requires that the extrajudicial confession should be voluntary and there should not be any coercion, any kind of threat, that you have not elicited anything from the cross-examination.
Lordship, he is the not voluntary saying, and he is the forcibly. That you have to establish from evidence. Have any of the other witnesses said that?
Cross-examination में एक साक्षीर किसी आनी नहांती, यदि अन्य कोई साक्षी जरिया किसी आनी चंदी, we will see that.
Other point, cross-examination, the accused and the deceased were living together peacefully. Then someone finally sudden.
से लाइन टा अच्छी, से समाने ठीक से रहुतिले, शांतिरे रहुतिले. That is one line in your favor. But a witness रो जो a part रो negative करिवा पाई, at least a जो गोटी line आनले, that is not sufficient. जे पंचायत मीटिंग हला, पंचायत मीटिंग रे आपण कन्फेस कले अन्य मानक सामने रे जे आपण को स्त्री को चरित्र को संदेह करी ताको मारी चंदी टांगिया. एटा माने जेरारे it has not been shaken, or it has not been, that person has not been cannot be disbelieved say जो line टी थी. हाँ अन्य कौन सी जरिया जब किसी बाहर कर जाएंगे we will see that.
Lordship, PW3 Lordship.
You come to PW2 serially very best. Come to PW2.
Lordship, I know the accused and the deceased. They are my co-villagers. The deceased, who is the wife of the accused, died about 2 years back on the date of occurrence, which was immediately before Dasara during evening hours. One Bhagirathi Naik came and reported that the accused had killed the deceased by a tangia. On hearing the news, we rushed to the house of the accused and found the deceased lying dead on the veranda of the house with bleeding injuries. Thereafter, a meeting was held in the village pertinent to the incident, and the accused was called to the meeting. On being questioned, the accused admitted his guilty by stating that he had killed his wife by a tangia because she was a bad character female. Thereafter, affair was lodged. Police came to the village, effected seizure of blood-stained tangia from accused Bhagavan Naik and prepared seizure list. I am a signatory to the same. Executed 2 is the seizure list. Executed 2/1 is my signature thereon. Thereafter, police also affected seizure of a check blood-stained lungi from the accused and prepared the seizure list. I am a signatory to the same. Executive 3 is the seizure list. Executive 3/1 is my signature thereon. Police also affected seizure of blood-stained earth and sample earth from the spot and prepared the seizure list in my presence. Executive 4 is the seizure list. Executive 4/1 is my signature thereon. Thereafter, police performed inquest over the dead body and prepared the inquest report. Executive 5 is the inquest report. Executive 5/1 is my signature thereon. The accused, while in police custody, admitted his guilty. His confessional statement was reduced into writing in my presence, and I am a signatory to the to it. Executive 6 is the disclosure statement of the accused. Executive 4 is my signature thereon. Executive 6/1 is my signature thereon.
Yes. Now come to the cross-examination.
It is not a fact that the accused was put under duress before his confession in the village punch. I have not asked any question to the accused in the village punch. It is not a fact that no panchayat was held in the village pertaining to the incident. It is not a fact the accused did not confess his guilty before the village punch.
Now come to PW3.
I know the accused and his deceased wife Radhika, who died about 2 years back. They being my co-villagers, about 2 years back, prior to Dasara during evening hours, one Mutinaik of our village came and told me that the accused had killed the deceased. On hearing the news, I rushed to the house of the accused and saw the deceased lying dead on the veranda of his house with bleeding injuries. There was a dead infant child lying by the side of the deceased. Pertaining to the incident, one meeting was held in the village. The accused did not come. Later on, after lodging of affair, when the police came to the accused was brought, I did not go to the police station to lodge affair. Police performed inquest over the dead body of the deceased. Executive 5/2 is my signature. On Executive 5 already marked. Executive 7 is the inquest of Radhika's infant child. Executive 7/1 is my signature. There, cross-examination. The accused and the deceased were staying peacefully as husband and wife for about 8 to 9 years. I do not know of any quarrel between the accused and the deceased immediately prior to the death of the deceased.
So, so far as this witness is concerned, the evidence of this witness is helpful to the extent that though he stated that a meeting was convened after the incident, and but the accused did not come to that meeting. So this line is helpful to you. Okay, come to the next one.
PW4. On 11/9/2006, I was at Mudilpada PS. On that day, CY337 Sarat Chandra Jena came and produced before Sri Ramanchal Sabar the wearing apparels of the deceased Radhika, namely one white color saree and command certificate bearing number 14 dated 10/9/2006, and the IU seized the same and prepared the seizure list. Executive 8 is the seizure list. 8/1 is my signature thereon. I am acquainted with the handwriting and signature of Sharat Chandra Jena. Having worked together, he also signed in my presence. Executive 8/2 is the signature on Executive 8 already marked. Cross examination, it is not a fact.
Okay, now come to the next PW5. The doctor who
Doctor
conducted postmortem examination.
Let's see.
And what type of injury he saw?
External injury, let's see. Injury over the back on the left.
The line of this also occipital vision. So, cause of death is due to intracranial hemorrhage and puncture of lungs. Profuse hemorrhage leading to soften the point of death. So there was a puncture wound on the left lung, and there was also a head injury. So these are the injuries which are responsible for the death. Another postmortem was conducted over a newborn child. So ତା ପାଇଁ ତ କିଛି charge ନାହିଁ.
Charge na investigation na complaint na kichhi.
अच्छा. Then you come to PW6.
Lordship, cross examination of the doctor.
Please.
During the time of occurrence, if the disputant parties are armed with pointed weapons and they attack each other, then the injuries found on deceased Radhika can accuse. It is not a fact that I have submitted the PM reports.
No, this type of question should have been asked where there are eyewitness to the occurrence and you brought out some material that ଦି ଜଣ ଯାକଙ୍କ ହାତରେ weapon ଥିଲା ଏବଂ ସେଠି ଗୁଡାକ ପଚରା ଯାଏ. It is a case where there is no direct evidence. ତେଣୁ there was no justification of asking this question. The cause of death appears to be not disputed. It is a case of homicidal death. Now you come to PW6.
I know the accused standing in the dock. I also know the informant, Bhaktaram Pujari. Deceased Radhika is the wife of the accused. A newborn child of the accused and the deceased also died on that day. Along with the deceased, Radhika died about 2 years back in her husband's house. During Dasara time, she was assaulted by means of the tangia on her neck and other parts of the body by her accused husband, as a result of which she died. And while the occurrence took place, she was holding her infant child in her hand. The child fell to the ground and died because of the fall. After the occurrence, there was a panchayat in the village which was attended by all the villagers and the accused, and on being asked, admitted his guilty, saying that he had killed his wife by means of the tangia before everybody. Thereafter, affair was lodged at the PS. I was examined by the police in connection with the case. Cross-examination. I have not seen the occurrence taking place. I did not go to call the accused to the village meeting. It is not a fact that the accused was put under duress. It is also not a fact that the accused did not confess his guilty before the punch. The accused and the deceased were staying as a husband and wife and having children. They had no history of quarreling with each other.
Okay. So the lines which you have brought in the cross-examination, that there was no quarreling, and from number 1 that they were living peacefully. This can be said that there was no motive behind the commission of the offense. And in a circumstantial evidence case, motive has its own significance. So that is a part which is in our favor. All right, come to PW7.
I know the accused, deceased informant, and infant child of Radhika. Deceased Radhika is the wife of accused. Radhika died about 2 years back in her husband's house. During Dasara time, she was assaulted by means of a tangia on her neck and other parts of the body by her accused husband, as a result of which she died. And while the occurrence took place, she was holding her infant child in her hand. The child fell to the ground and died because of the fall. After the occurrence, there was a panchayat in the village which was attended by all the villagers and the accused, and on being asked, admitted his guilty, saying that he had killed his wife by means of a tangia before everybody. Thereafter, affair was lodged. As the PS, I was examined by the police in connection with the case. Cross-examination. I have not seen the occurrence taking place. I did not go to call the accused to village meeting. It is not a fact that the accused was put under duress. It is also not a fact that the accused did not confess his guilty before the punch. The accused and the deceased were staying as husband and wife and having children. They had no history of quarreling with each other.
Okay, the last witness is the
APW8. On 28/12/2007, I was in my present post. On that day, I took over the charge of investigation of the case by Module Pada PS case number 2020 dated 11/9/2006 under section 302 IPC from SIR Sabar on his transfer. During course of investigation, I perused the case records and connected documents of the case, and on 15/1/2008, I re-examined the witness Murthy Naik and Bhagirathi Naik. On 18/1/2008, I sent the exhibits to RFSL Barampur through SDJM Malkanagiri. Exhibit 12 is the copy of forwarding report. Exhibit 12/1 is my signature thereon. On 14/6/2008, on receipt of orders from SP Malkanagiri, I submitted charge sheet against accused Bhagavan Naik under section 302 of IPC. The preliminary investigation has been done by Ramchal Savar. He has gone to Raigada district on transfer. It is learned that he is on long leave. During the course of his investigation, he prepared certain documents. I am acquainted with his handwriting and signatures as because he worked under me. Exhibit 1/3 is the signature and endorsement of SI Ramchal Sabar. Exhibit 1/4 is the formal affair. Exhibit 1/5 is the signature of Ramchal Sabar. Exhibit 2/1 is the signature of Sri Sabar on Exhibit 2 already marked, which is the seizure list. Exhibit 3/2 is the
stated about the formalities of the
seizure.
investigation. So the only, as it appears, the only evidence against you is that a meeting was held in the village and villagers assembled there, and you were called to the meeting, and in that meeting you stated that you have killed your wife because you are doubting the his character, her character. That is all. That is it. So what is your submission?
Let's say he is the confess of the villagers, do not volunteer, and he is the forcibly admit.
There is no forcible. Here nobody, you have not brought out any evidence that he was assaulted or he was reluctant to disclose, and he was pressurized for which he made the disclosure. It is not like that. The evidence is that he was called to the meeting and he was asked about and he confessed. Question is that whether it is a voluntary one or not. The situation is that it is a meeting place. So many persons might be also attending that meeting. Whether in such a scenario, if somebody states that I have killed my wife, whether it would be acceptable in view of the keeping in view the provision under section 24 of the evidence. How do you satisfy?
There are two confessions in this matter. One is before the village punch, thereafter the FIR was lost. Thereafter another confession before the IO. Basing upon
that is
yes.
not confession in the IO law.
It is
that is inadmissible.
Yes, sir.
No.
Basing upon this, the leading to discovery was
How do you justify
discovery of what?
Weapon of offense. Exhibit 6 is the statement and the seizure list.
Exhibit
6, Your Lordship.
What is Exhibit 6?
Exhibit 6 is the seizure list by which the weapon of offense was discovered at the instance of the accused one.
Wait.
Disclosure of statement. From where was it discovered? I mean, where did he lead the police?
LCR ଟା ଏଠି available ନାହିଁ ତ I can't.
नहीं पुलिस ର statement ଥିବ ସେ ଯୋଉ IO PW9
Weapon of offense means the tangia.
Tangia, yes.
The tangia was having no blood. That is the chemical examination report. And where from it was recovered?
lungi of the deceased has
ଆଇଏ ତ ସେମିତି କିଛି କହିନି
ସେ
ନାହିଁ
recover ସେ କହୁଛନ୍ତି ଧରିକିରି ଠିଆ ହେଇଥିଲା ବି
କୋଉଠି
ମାନେ ମାରିକିରି କୁଆଡେ ଧରିକିରି ଠିଆ ହେଇଥିଲା ମାନେ କିଏ କହୁଛି some villagers
No.
ସେମିତି
Villagers
କିଛି ତ ନାହିଁ statement.
ସବୁ ତ evidence ଆମେ ପଢଲୁ କେହି ତ କହୁନାହାନ୍ତି ସେ FIR story କୁ no, that is not the
Exhibit 6
substantive piece of evidence. Nobody has stated that you are present at the spot holding that tangia. The PW1 is the informant in the case. He has simply stated that he came to the spot hearing about the death. Then he found the deceased was lying dead and he was having injuries. Then a meeting was held and you are questioned.
FIR ରେ ସେ କହିଛି ଲାଷ୍ଟ ଲାଇନ ରେ ଘଟଣାସ୍ଥଳକୁ ଯାଇ ଦେଖିଲେ ରାଧିକା ନାୟକ ନବଜାତ ଶିଶୁ ପୁଅ ଗଭୀର ଆଘାତ ପ୍ରାପ୍ତ ହୋଇ ଅଗଣା ସାମ୍ନାରେ ମରି ପଡିଥିଲେ ଏବଂ ରାଧିକା ନାୟକର ସ୍ୱାମୀ ଉପରୋକ୍ତ ଭଗବାନ ନାୟକ ଟାଙ୍ଗିଆ ଧରି ବାଡ ପାଖରେ ଛିଡା ହୋଇ ପାଟିତୁଣ୍ଡ
Madam,
କରୁଥିଲେ.
this is not the substantive piece of evidence.
I was just pointing out where
There is no evidence in court. Nobody has stated in court on oath that we have seen the because had it been said so during trial, the accused or the defense side would have got an opportunity to cross-examine the witness. So you cannot utilize this FIR story.
Only the exhibit 6.
No, you have not examined the IO. IO was on long leave. Somebody else has come and deposed. So there you have missed out.
Exhibit 6 may help.
Yeah, maybe there. But...
And how do you say that it is the weapon of offense? You can say one tangia was recovered at the instance of the appellant. That much you can say. But how do you connect it with the accused? Or that this is the weapon of, because there is no eyewitness to the occurrence.
There is no eyewitness.
So you can say one tangia which on chemical examination found to have been contained no blood was recovered at the instance of the appellant. That much you can say. And that IO who has who is the best witness to say so has not been examined.
Not been examined.
No, and the IO who has been, I mean, the police officer who has been examined also does not state about recovery of the tangia.
Has that IO stated so? PW8 that he said that I will show that place where I have concealed the weapon of offense.
He only says
he only proves
exhibit 6 is the signature of C. Sabar.
That is not the way when 27 प्रमाण करिया फेले accused IO कहिवा दरकार जे आकु मु कस्टडी को नेला परे से कहिला जे मु अमक जगह रे वेपन टा को लुचेकिन रखिछि मु से जगह को नेकिनी आपन को देखै देबी एवं यहा कहि से आमकु बा मते एवं साक्षी मान को नेकी गला एवं से जगह देखैला से जगह रु ए जिंसटा बाहरला ए जिंसटा ई सीजर लिस्ट रे जबत हला एटा होउची तारो स्टेटमेंट एटा होउची से जबत तालिका एटा होउची से एक्ट्स हला ए जिंस कहले आपण 27 रे ताकू
admissible
we can take it in account. Otherwise एटा होउची तार डिस्क्लोजर स्टेटमेंट खाली गोटे प्लेस ये करिसंती exhibit 6 by 2
the signature and
6 is the
statement ର କିଛି ଆଉ କିଛି କହିଲା
and 630 version
confession statement consistent ଅଛି
on exhibit 6 Here seizure list है
Exhibit 6 मिला
exhibit 6 था जी जो
हाँ
disclosure statement था but
Tangier
Tangier पर
Tangier को सीजर लिस्ट से सीधे
कितना नंबर
bearing apparel bearing apparel तले नहीं Tangier को ये रह जाना पड़ेगा
Tangier to exhibit 2
exhibit 2
हाँ this is your deal
अच्छा that one
exhibit 2 रे आपनकर जो माने को प्रेजेंस रे से टांगिया जबत ହେଇची से मानकर मध्य सिग्नेचर निया ହେଇची but nobody has come forward to depose that any such statement was made by the accused or the appellant accused and he led the police party to the place of concealment and from there he brought out that tangia and produced so that is not there.
Two witnesses have signed. Have the state Bhaktaram Pujari.
They have been examined.
Bhagwan Naik is the accused. Bhaktaram Pujari and Dambu Pujari.
Bhaktaram Pujari is the informant, PW1. See किसी कोई नहीं PW2 तारा exhibit मैंने कहीं से but explain करेंगे.
मैंने कौन पढ़ी?
मैं पढ़ PW2 ये May I read page 36?
Yes.
Last question. Police also effected seizure of bloodstain earth and sample earth from the spot and prepared the seizure list in my presence. Exhibit 4 is the seizure list and 4.1 is my signature thereof. Thereafter, the police performed inquest over the dead body and prepared the inquest report. Before that,
thereafter, FIR was lodged.
FIR was lodged. Police came to the village, effected seizure of blood-stained tangia from the accused Bhagwan Naik and prepared seizure list and the signatory to the same. Exhibit 2 is the seizure list and Exhibit 2/1 is the signature thereafter.
The disclosure statement, nobody has.
Say
disclosure statement is
leading to discovery.
May I read it? May I read?
Oh, read.
Thereafter, the police also effected seizure of the checked blood-stained lungi from the accused and prepared the seizure list. I am a signatory to the same. Exhibit 3 is the seizure list and Exhibit 3/1 is my signature thereof. Police also effected seizure of blood-stained earths and sample earth from the spot and prepared the seizure list in my presence. Exhibit 4 is the seizure list. Exhibit 4/1 is my signature thereof. Thereafter, the police performed inquest over the dead body and prepare the inquest report. Exhibit 5 is the inquest report and Exhibit 5/1 is the signature thereof. This is relevant closure. The accused, while in police custody, admitted his guilt. His confession statement was reduced into writing in my presence, and I am the signatory to it. Exhibit 6 is the disclosure
Madam,
statement.
this is inadmissible.
This is
question is that so much of information
leading to
that would be only otherwise it would be hit by section
24 and
25 of the evidence. ତେଣୁ ଯଦି ସିଏ କହିଥାନ୍ତା accused ଏଇ statement ଦେଲା ଏବଂ ତାପରେ leading କରିକି ନେଇକିନି ଗଲା ଏବଂ ତାପରେ ସେଇଟା admissible ହେଇଥାନ୍ତା. accused ମୋ ପାଖରେ confess କଲା ଏବଂ ମୁଁ statement ଟା ଇଏ କଲି. This is totally inadmissible. Then accused ଗୋଟେ ଆଣିକିନି କଣ accused to ସେଟା ବାହାର କଲା. That is just a seizure.
Yes,
but the main connection is that leading to discovery.
That is not connecting with the exhibit. Yes, I'm conscious here. Exhibit 6 and exhibit
2 କହୁଛି ମାନେ accused leading to discovery କଲା of the weapon ନା କୌଣସି ସାକ୍ଷୀ କହୁଛନ୍ତି. The place should be also such a place where the others cannot
Exclusive.
take notice of it.
That should have
Must
been
be a
exclusive knowledge of the
concept,
appellant.
ଗୋଟେ open ରେ place କରିଥିବ ତ place ଟା ଏମିତି ହେଇଥିବା ଦରକାର ଯେ accused ର exclusive knowledge ଥିବା
Knowledge.
ଦରକାର ଏବଂ ସେଇ knowledge ଯଦି ଥିବ he has to explain it that how
he's,
where he kept.
yes.
Apart from the fact that you are to prove also the link of that weapon with the crime in question. ତେଣୁ ଆପଣ ଯଦି ବି ଗୋଟେ ଖାଲି ଏଠି ଏଇ statement ରୁ ଜଣା ପଡିବ ଯଦି ଗୋଟେ ଟାଙ୍ଗିଆଟା accused to ଜବତ ହେଇଥିଲା but when there is no evidence that accused lead to the discovery of that tangia, moreover chemical examination report jota apna praman karichandi exhibit 17 which
That's
is
there
at
is no
page
blood.
number 47 of the paper book, there is no blood on that tangia. So have you brought out any decision that if a confession is made in a meeting, why it would be acceptable or not acceptable? Because so many persons should be there. In such a scenario, it is not expected that somebody would say something voluntarily. So the surroundings are to be also taken into account. That is why whether in such a situation କିଛି ଲୋକ ତାଙ୍କୁ ଡାକିଲେ ଗୋଟେ ମିଟିଂ କଲେ ମିଟିଂ ଡାକିକିନି ତାକୁ ପଚାରିଲେ ସେ ଯଦି ବି ଏଇଟା କହିଲା it would not be a voluntary one so as to attract that 24 ଆପଣ ଆଣିଛନ୍ତି କି this ଦେଖି
I don't have adequate copies also.
ନା ନା ଠିକ ଅଛି
There are two decisions I'm relying on. One is of 1975, 4 SSC 234. This is regarding the evidentiary value of the extrajudicial confession made to a punch. Which you have marked the paragraphs.
just a minute 1975
4 SSC 234. The paragraph 5 to 7.
paragraph 5
5 to 7.
paragraph 5
That includes paragraph 5 is regarding the extrajudicial confession. 6 and 7 is regarding the
no in this case where the confession was made
before the village function.
ପଢନ୍ତୁ This place paragraph number 5 you are relying on? Yes. ଏଇଟା village meeting ରେ ହେଇଥିଲା ବୋଲି କୋଉ paragraph ରେ ଅଛି?
I'll just take a minute. May I please paragraph 5?
Yes.
The second contention put forward by the learned counsel for the appellant was that there was no material corroboration of the statement of the approver, and the High Court had convicted the appellant on the basis of the extrajudicial confession made by the two accused persons before some persons, but that could not in law be regarded as any corroboration at all, because one tainted evidence cannot corroborate another tainted evidence. The evidence furnished by the extrajudicial confession made by the accused to the witness cannot be termed to be a tainted evidence, and if corroboration is required, it is only by way of abundant caution. If the court believes the witness before whom the confession is made and it is satisfied the confession is voluntary, then in such a case, conviction can be founded on such piece of such evidence alone, as done in Rao Shiv Bahadur Singh versus State of UP, where the lordships of the Supreme Court rested the conviction of the accused on the extrajudicial confession made by him before two independent witnesses, namely Gadkari and Perulakar. In the instant case also, after perusing the evidence of PW3 and PW12, we are satisfied that so that is regarding the fact of that
No,
case.
dude.
Yes,
No, in this case, you see paragraph 6 re,
yes, sir.
that there was sufficient
Corroboration.
circumstantial evidence
Yes, sir.
apart from the extrajudicial confession.
Yes.
So those were also discussed here.
Your Lordship.
So it is not that merely on the extrajudicial confession, this conviction.
In that case also there is recovery of weapon of offense which is disputed in present case. There is a disputed of recovery of weapon of offense and clothes of the person of the accused.
No, there are so many things. A blood ye match korthila.
Yes, sir.
Recovery of weapon rothila.
Scientific examination ta tally korthila.
अच्छा आठु जो जबत ହେଲା କୃପାଣଟା ତା ଧୀରେ ଯୋଉ ହେୟାର ଲାଗିଥିଲା ସେଟା ଡିସିଜ୍ଡ ର ହେୟାର ବୋଲି ସାଇଣ୍ଟିଫିକ ଏକ୍ସାମିନେସନ ରୁ ପ୍ରମାଣ ହେଲା ଏଇ ଜିନିଷ ଗୁଡାକ ସବୁ ରହିଥିଲା. What is the next one?
That particular decision, paragraph 7 also would be relevant. Lastly, there was evidence of extrajudicial confession made by the Magar Singh to Kartar Singh. That was the analysis of the court. May I read? To Sarpanch. Lastly, there was the evidence of extrajudicial confession made by the Magar Singh to Kartar Singh Sarpanch and Jeet Singh PW12, which was proved by PW12. Even Srimati Swanso made a clear breast to the whole story in a statement to Bachchan Singh PW4 when he inquired as to how the deceased had been murdered. To crown it all, there was a question of the motive. Surjit Kaur has also clearly admitted that the deceased has made a will in favor of Pichalgu, son of Baldev Singh. It was also admitted that previous to that, the deceased has made a will in favor of his brother Sarwan Singh. And the accused, thinking that the deceased might change his mind again, planned the murder of the deceased so that he may not be in a position to change his mind and make a will of his property in favor of the Sarwan Singh. This provided sufficient motive for the murder. This court is on appeal by specialty, does not go into the evidence, but even after going through the evidence in this case, we are satisfied that the prosecution has been proved against the two accused persons beyond any reasonable doubt. This is regarding the motive part. May I please see next judgment?
Yes. Which paragraph?
Paragraph 7.
ଏଠି କୋଉଠି ହେଇଥିଲା extrajudicial confession ଟା?
Just take a minute.
Paragraph 7.
Paragraph 7. May I please? The question that emerges, therefore, is whether the prosecution has established the three circumstantial evidence heavily backed upon by the prosecution in proof of the guilt of the appellant. The first circumstance is that the deceased and the appellant were last seen together by PW 7 and 8. From the evidence, it is clear that there is no prior intimacy of the appellant and the deceased. They happen to meet per chance. Equally, from the evidence, it is clear that PW 7, the liquor shop owner, and the PW 8 who had liquor with the appellant and the deceased are also absolute strangers to the deceased and the appellant. Admittedly, there is no identification parade conducted by the prosecution to identify the appellant number 7 and 8. The appellant has stated to have pointed out to PW7 as one of the sold the liquor and PW8 consumed it with him and the deceased. Therefore, it is not reasonably possible to accept the testimony of PW7 and 8 when they profess that they have seen the appellant and the deceased together consuming the liquor. It is highly artificial and appears on the face of it make believable story. The next piece of evidence is the alleged extrajudicial confession made by the appellant to PW10. An unambiguous extrajudicial confession poses the high probability value for as it emanates from the person who committed the crime and is admissible in evidence, provided it is free from suspicion and suggestion it is falsity. But in the process of the proof of the alleged confession of the court, the court has to satisfy that it is a voluntary one and does not appear to be result of inducement, threat, or promise envisaged under Section 24 to the Evidence Act, or brought out about in suspicious circumstances circumvent under Section 25 or 26 of the Evidence Act. Therefore, the court has to look into the surrounding circumstances and to find out whether the extrajudicial confession is not inspired by any improper or collateral consideration or circumvention of the law suggesting that it may not be true one. For this purpose, the court must scrutinize all the relevant facts, such as the person to whom the confession is made, the time and place of making it, the circumstances in which it was made, and finally the actual words used by the accused. Extrajudicial confession, if found to be voluntary, can be relied upon by the court along with other evidence on record. Therefore, even on the extrajudicial confession will also have to be proved like any other fact. The value of the evidence as to the confession depends upon the veracity of the witness to whom it is made and the circumstances in which it came to be made and the actual words used by the accused. Sometimes it may not be possible to witness to reproduce the actual words in which the confession was made. For that reason, the law insists on recording the statement by a judicial magistrate after admission.
That's so here. You have examined 4 witnesses.
Yes, sir.
So far as that meeting is concerned.
Yes, sir.
PW1, 2, 3, and 6.
Your Lordship, 1, 2, 3, 6, and 7.
7 is also there.
7 is also there.
Okay, 7.
All of them stated that apart from PW3, all
so PW3 stated that accused did not state anything. Did not
he
come.
says he was not present in the meeting.
Now, the other 4 witnesses,
yes, sir.
Out of which PW1 has stated that he was hiding and he was called.
Yes, called.
And then in the meeting place, he was asked, he was questioned. That is the
on being
evidence.
Asked. Yes, sir. On being asked.
Question is that if a meeting was held and he was questioned,
yes, sir,
about and such type of statement is made,
yes, sir,
can it be a voluntary one or
yes,
not?
So may I place the deposition of PW 6 and 7 for a minute?
Yes. Because apart from that,
yes, sir,
there is no other
there
evidence.
is no other linking here.
କାରଣ ଆପଣ ସାକ୍ଷୀ କହୁଛନ୍ତି ତାଙ୍କ ଭିତରେ ରିଲେସନସିପ ଭଲ ଥିଲା, ସେମାନେ ପିସଫୁଲି ରହିଥିଲେ.
There may not be having any pre-mediation, but there are 2 persons have been killed.
No. Forget about one. There is no charge.
There is no charge.
The child was lying dead.
Yes.
So how she died, nobody knows. You are also not framing charge. So you cannot say that we have to look into that one child was lying dead.
Yes, sir.
So the accused must have been there is no question of assumption here.
Yes. May I place
charge is framed only against the accused for commission of murder of his wife. And the only evidence available on record is the confession made in a village meeting by the appellant, right?
Yes. May I place a PW6 deposition? Yes. I'll reread the entire thing. I know the accused standing in the door. I also know the informant Bhagatram Pujari. Deceased Radhika is the wife of the accused, a newborn child of the accused, and the deceased also died on that day along with the deceased. Radhika died about 2 years back in her husband's house during Dashera time. She was assaulted by means of a tangia on her neck and other parts of the body by her husband, as a result of which she died. And while the occurrence took place, she was hiding her infant child in her hands. The child fell into the ground and died because of that fall. After the occurrence, there was a panchayat in the village, which was attended by all the villagers, and the accuser, on being asked, admitted his guilt, saying that he had killed his wife by means of a tangia before everybody. Thereafter, FIR was lodged as the TS. I was examined. Thereafter, the cross-examination. I have not seen the occurrence taking place. I did not go to call the accused to the village meeting. It is not a fact that the accused was put under duress. That suggestion would be relevant, Your Lordship.
Which suggestion?
That it is not a fact that the accused was put under duress. The suggestion would be relevant because it shows that he was not forced. There is no compelling circumstances for the accused to make the
Compelling circumstance. You see, in the chief examination itself, it appears that she was asked about the occurrence.
Yes, Your Lordship.
She was called to the meeting. She was
could have
hiding.
remained silent, Your Lordship.
He was hiding somewhere. He was called to the meeting and questioned.
Yes, Lordship.
Voluntary माने कौन? Wording use है जाने तारो निजे जानिला तर उपलब्धि कला जे मु एटा ये करूची जहा करिची भूल करची तो गोटे अनुतप्त हला अनुतप्त है कि स्वतःप्रवृत्त भावरे यदि जनक पाखे कहबा दैट पर्सन
the relative
क्लोजली पर्सन सो ए टाइप रो हेले नले जे एक्स वाई जेड पाखे सी नहीं काई वॉलंटरली कन्फेस करियो nobody has seen the occurrence. So that is why it is always said that extrajudicial confession is a weak piece of evidence. Because it is seen that where the police does not get any type of evidence, they used to create such type of evidence. It's very easy to make such. So, circumstance a extrajudicial confession को लोकों प्रेजेंस एटी सर्कमस्टांस ता कोन गोटे गाँ रो सभा होउची सभारे गोटे लोक नुची किनी रहिची ताकू तमे डाकिलो सभा डाकिनी ताकू क्वेश्चन पचारलो सेठी से कहिला एटाकू वॉलंटरी कुहा जाई परिबो की वॉलंटरी रो माने कोन you see that what is voluntary somebody when comes to realize that whatever he has committed is a mistake. I've committed something which I should not have done by way of repentance or something like that. He discloses before others. Then that would be see that he has signed before whom says my question kaha pakre kala repose kala confidence. Who circumstance eta kahila kon kahila actual words.
Exactly.
Those are very relevant. Apart from the fact that we have to keep in mind that it is a very weak piece of evidence because it is very easy to create such type of evidence. तीन चार जन लोक आसिले कहिला आसिला विलेज मीटिंग रे कहिदला इति कहि भारी माने इजी ना जन को 302 रे लाइफ इन्फिनिटी दबो ए टाइप रो एविडेंस है so when you yourself your witnesses have stated that they were living peacefully happily.
They're living.
And how these witnesses have stated that see taku ta chua taku pole re dharitela amak re dharitela so are they truthful witnesses? Semane to totally
there is no eyewitness. There is absolutely no eyewitness.
Here's evidence, Lordship.
semane kemti janile je ghatana hela bele see ta chua taku pole re dharitela सेज में सेज ने मारिला छुआ टर बाजिला
पडिगला अन मरिगला सिचुएशन
यू टाइप रो स्टेटमेंट दोउछंदी सेतरु जणा पुडची जे तांकर किते they are interested even though they have not seen anything छुआटा ता हातुरु पडिगला डायरेक्ट से पडिवा जोगु मला why have you not found out the decisions?
No, Lordship, one decision सेटा माने मो पाखे नाही किंतु सेटा होची प्रशांत कुमार साहू व्हाट इज स्टेट ऑफ ओडिशा 1998 15 OCR 581 the ground of extrajudicial confession cannot be accepted and evidence adduced is suspicious. सेटा मो पाखे नाही सेटा
decision पडिचन
ना ना Lordship सेटा
से decision पडिचन कौनसी डिसीजन प्लेस करिवे सेतेबेले आगे से डिसीजन टा पढिबे तार फैक्चुअल सिनेरियो कोन को कॉन्टेक्स्ट रे से ऑब्जर्वेशन टा हेची गुडा सब देखि किनी तापरे प्लेस करिवे गुडा कोड से हेड नोटिंग देखि किनी एमती प्लेस करा जाय जे जेमती लाइन बाय लाइन प्रिपेयर करिन आछंदी ए लाइन गुडा का इंपोर्टेंट एक्स्ट्रा जुडिशियल preparation should be up to that standard. So you are getting a scope to argue a case in 302 in the High Court, and people are watching you. You know that it's a live streaming. So your performance is being watched. So your preparation should be also like that. Are you aware that these proceedings are watched even in the evening hours by the judicial officers, the students? They were also watching this proceeding. So ଭଲ୍ୟୁଣ୍ଟାରୀ ତାକୁ ଆପଣଙ୍କୁ ଏଠି କାଟିବାକୁ ପଡିବ। ଏଇ circumstance ରେ ଭଲ୍ୟୁଣ୍ଟାରୀ ମାନେ କଣ? ଏଠି ଯୋଉ ସିଚୁଏସନ ସେଇଥିପାଇଁ ଏଠି ସୁପ୍ରିମ କୋର୍ଟ କହିଲେ ଯେ the circumstances in which it is made is also one of the relevant factor while the court will appreciate the extrajudicial confession. ତେଣୁ circumstance ଟା କଣ ହେଲା? ତେଣୁ circumstance ଟା ହଉଛି ଗୋଟେ village meeting. ଭିଲେଜ ମିଟିଂ ରେ ଦଳେ ଲୋକ ବସିଛନ୍ତି, ଘଟଣାଟା ଗୋଟେ ହେଇଯାଇଛି, ଆକ୍ୟୁଜ ଲୁଚିକିନି ରହିଛି, ତାକୁ ଡକେଇଛନ୍ତି, ଡକେଇ ତାକୁ ତା ଉପରେ ସେ ଘଟଣା ଉପରେ କ୍ୱେଶ୍ଚିନ୍ସ ପଚାରିଛନ୍ତି, ସେ କହିଛି ମୁଁ ମୋ ସ୍ତ୍ରୀକୁ ମାରିଦେଇଛି। ଏଇ ସର୍କମଷ୍ଟାନ୍ସ ଟାକୁ ବା ଏଇଟାକୁ କୁହାଯାଇ ପାରିବ କି ଯେ ସେ ସ୍ୱତଃପ୍ରବୃତ୍ତ ଭାବରେ କହିଲା। So the wording that has been used in section 24 is that it was without any inducement, promise, threat, etc. All these things are there. So apart from that, the judicial interpretation is that it should be voluntary one. kaha pakhre confidence repose kala, ko circumstance re ita kuha gala, kon words use kara gala, se kahila, e sabu ku ro madhya relevance ଅଛି। He has taken a plea that he was not called to the meeting at all. पंचायत को मते
Exemption of case. Let's see. Let's see day after tomorrow.
The meaning of
Lots.
body moved out with distance. Realize now. He depends on the as a cartoon. See would ask me how did it body Sajio like that.
ସେତିକି କ୍ଲୋଜନେସ୍ ନ ଆସିଲେ ସେ ଭଲ୍ୟୁଣ୍ଟାରୀ
କ୍ଲୋଜନେସ୍ ଗୋଟେ ଜିନିଷ ଆଉ ଗୋଟେ ହଉଛି ଯେ ତାକୁ କିଛି କଣ୍ଟେଷ୍ଟ କରି ତାକୁ ସାହାଯ୍ୟ ପାଇବ ସେଠି ମଧ୍ୟ ହୁଏ ଦେଇପାରେ କିନ୍ତୁ ସିଚୁଏସନ ସେଇ ଟାଇପର ପ୍ରତିଷ୍ଠାନ ଉଦ୍ଧାର କରିବା ଏଇଟା ତାଙ୍କ ସାଙ୍ଗରେ କେତେ ବର୍ଷ ସମ୍ପର୍କ ଥିଲା ବା କେତେ ବର୍ଷ କାହିଁ ସେ ତାପରେ କନଫିଡେନ୍ସ that is why it put the confidence on XYZ and
सर डाउट भी आସୁଛି हाँ मीटिंग रे से एडमिट करते कि पुलिस पाखरे एडमिट कारण PW2 कहूची जे
एफआईआर टा क्लियर अछि
पुलिस आछि इन्वेस्टिगेशन क्लियर सेठी ଗୋଟେ disclosure statement report that's it completely different but prior to the lodging of the FIR yes the meeting was started and in that meeting this statement was made by ସେଇଟା ତାପରେ କେସ୍ ରେଜିଷ୍ଟର୍ଡ ହେଲା ଇନଭେଷ୍ଟିଗେସନ କଲା ତାପରେ ଆପଣଙ୍କର ଷ୍ଟେଟମେଣ୍ଟ ରେକର୍ଡିଂ ଡିସ୍କ୍ଲୋଜର ଷ୍ଟେଟମେଣ୍ଟ you prepare day after tomorrow will take off that harding part of the but देखा नहीं से माने ये करते और दोनों का डाल दिया ना we are marking in the list because this is for the entire week so काली के करियो ଆଉ ଗୋଟେ
item 9
ଗୋଟେ ମ୍ୟାଟର କୋଉଟା ଗୋଟେ ଅଧାରୁ ଆରମ୍ଭ ହେଇଥିଲା yes বহি citation দুটা করে item 4
my lord. Will agree the matter that is clear.
हां थोड़े कौन है जी
Item 4 my lord, that I can see nothing my lord. I am Radharam Das like, but in Mr. Dipali Mahapatra instead of Ramjan Kumar Rana.
Order number so and so may kindly prisoner's petition regarding engagement of advocate Dipali Mahapatra instead of so and so.
I am Radharam Das like. I was engaged as a legal aid my lord. Earlier Mr. Rana was engaged.
Dipali Mahapatra को से request
କହିଲି ତାଙ୍କୁ କଣ ପଚାରିଥିଲି ସେ ମନା କରୁଛନ୍ତି ଯେ ଆଉ ବହୁତ ଆଉ ଯେ appointment ହବ
so if she says no then you can argue there is no problem
she custody 9 my lord that is and
why don't you request Miss Mahapatra
I have requested come to the court
that she is not interested that's all just you are already there so if she says no she is not interested then we can hear you
I'm Radharam Das like
no we follow
my name not is like instead of Rana ଲେଖା instead of Rana
କୋଉଠି ତ ଅର୍ଡର ଅଛି ମିଷ୍ଟର ରଣା ବୋଲି ଆପଣ କେବେ ଏନଗେଜ ହେଲେ
2 ରେ my lord ମୁଁ ଅଛି ବି ନାମ ଅଛି ଲେଖା
ନାଇଁ ବି ନାମ ନାଇଁ ଦେଖିଦବା ଡାକ୍ତର ଭୋଇ
ଡକ୍ଟର ଭୋଇ
ଟୁ ଅର୍ଡର୍ସ ଆର୍ देयर वन नन ऑफ योर्स और ଗୋଟେ ନାହିଁ ତ order number 2 dated 11/10/2022 none appears
ତାଙ୍କର ରାଧାରମଣ ଦାସ ନାୟକଙ୍କର वकालतनामा କିଛି ଅଛି କି
ଅଛି
ତ ଦେଖିଦବା
ରଞ୍ଜନ କୁମାର ରଣା ଜାଗାରେ
ନାଇଁ 13/1/2025 order ଅଛି ରଞ୍ଜନ କୁମାର ରାଣା is not appearing
ତାପରେ ମତେ ଏନଗେଜ
ତାପରେ to get ଆରେ ନାହିଁ order ବୋଲି ଆମେ କହୁଛୁ ପରା Counsel for the state had been asked to obtain instructions regarding status of the appellant. And if he wants to engage any other counsel. ତାପରେ ସେ କହିଲେ ଆପଣଙ୍କୁ engage କରିବେ ବୋଲି ଦୀପାଳି ମହାପାତ୍ରଙ୍କୁ କହିଲେ ଆପଣଙ୍କର କୋଉଠୁ ପାଉନୁ ଆମେ
ଅଛି ପାୱାର ଅଛି
ଓହୋ ପାୱାର ଅଛି ଯେ ପାୱାର ଟା ଆସିଲା କୁଆଡୁ ଏ ହାଇକୋର୍ଟ ହଁ ଏଠୁ ବାହାରିଲା ଗୋଟେ ନୋଟିଂ ଅଛି ଏଇ ଯୋଉ ଓଡିଶା ହାଇକୋର୍ଟ ଲିଗାଲ in 2022 ଅର୍ଡର ଏଠି ନାହିଁ କି
ଆସି ଲେଖା ହେଇଛି ଅର୍ଡରଟା 11/10/2022 ରେ ଗୋଟେ ଅର୍ଡର ହେଇଛି
ଓହୋ ତାଙ୍କ ନାଁଟା ଲେଖା ହେଇନି
the name of the assigned party be reflected in the cause list authority
ଆସାଇନ କରିବେ କଜ ଲିଷ୍ଟ ହବ ସେଇଟା ତାପରେ ଆସିନି ଆଉ ଠିକ ଅଛି ମିଳିଗଲା
ଓଡିଶା ହାଇକୋର୍ଟ ଲିଗାଲ ସର୍ଭିସ କମିଟି engaged Mr. Rana
ସେଟା ଭୁଲ ହେଇଯାଇଛି ତାପରେ actually engage ହେଇଛନ୍ତି 2022 ରେ High Court Legal Aid Services Authority has engaged in 2022. There is a noting in the note sheet. Order ରେ ନାହିଁ, note sheet ରେ ଅଛି.
ରଞ୍ଜନ କୁମାର ରାଣା ନା ଉପରେ ଲେଖା ହେଇଛି ଯେ ସେଥିପାଇଁ ଆମେ ଲେଖିଲୁ ସିଏ ଆପିୟର କରୁନାହାନ୍ତି କାରଣ ସିଏ ପ୍ରଥମରୁ ତାଙ୍କୁ ଦିଆହେଇଥିଲା ସେଥିପାଇଁ ପୁରା ଫ୍ରଣ୍ଟ ପେଜ ରେ ତାଙ୍କ ନାଁ ବି ଲେଖା ହେଇଛି ଫାଇଲର।
Better ହେଇଯାନ୍ତା.
Why don't you say to Ms. Dipali Mahapatra that she is not interested because the prisoner has sent a petition. We just will just mention it and he is already there. He will argue the matter. He is prepared. So he has Ms. Mahapatra has told him, but he should come to the court to say that no, I am not interested.
Tomorrow also if she mentions at any time we can take note.
It has now division Constitution.
No, we can take it.